Today, we're joined by founding attorney Barry Ansbacher. He's been practicing law for more than 35 years with a focus on real estate, construction, condominium, and community association law. He's widely recognized across the state and is notably one of the only attorneys in Florida to hold triple board certification, which is an achievement that we're very proud of. Partner Hannah Rulo leads our community association practice from our St. Augustine office. She's highly regarded for her experience in association governance, real estate litigation, and homeowners association law, and she's deeply committed to guiding associations with dedicated hands-on support. Today, we're also joined by attorneys Emily Dominguez, Alejandra Gonzalez, and Kelly Welch. They bring extensive experience in association compliance, governance, dispute resolution, and litigation. Together, our team has helped associations throughout Florida navigate complex legal and operational challenges for many years, and we're grateful to have them here today. A quick recap just before they begin their presentations. Please keep your Zoom connection live for the full webinar. Allow 10 business days for certificate processing. And if you don't receive that certificate after the 10 days, you can email us at marketing@ansbacher.net with your name, association, course date, and registration email. And again, if you are attending in a group, please reach out so that we can assist you with that. Okay, this is today's course roadmap. We're going to be covering governing documents and board duties, MRTA, which is mostly a topic for those in HOAs, elections and membership meetings, records, budgets, and insurance, milestones or SIRS for those in condos, followed by disputes as well as hot topics, and then we're going to conclude with that final Q&A session. Okay, so with that, we're ready to begin. I'm going to turn the program over to Barry Ansbacher, and he's going to begin his part of the course. Just 1 second.
I'm Barry Ansbacher. Thank you so much for joining us today. I'm going to go through a few of the chapters of the program and look forward to sharing a little information with you. So we're going to start with the basics. What is a condo? What's an HOA? And some of the terms that we're going to use throughout the program today that many of you may be familiar with, but not everybody. So let's make sure we're all starting with a good foundation. An assessment. An assessment is, some people call it a tax, but essentially it is a non-voluntary payment. Unlike a civic association where you may have a choice to pay or not pay, an assessment is a mandatory charge, meaning that if a condominium owner or a homeowner association member doesn't make this payment, that they would be subject to enforcement action and lien on their property even. An assessment is generally a reflection of the budget. In other words, if you take what the budget is for the year and you divide it by the number of homes, whether condo or single family, then that's generally going to be the assessment, though sometimes the payment may be split up a little bit differently. It is the anticipated regular payment, whether that's charged monthly, quarterly, or annually. A common element is going to be everything that is part of the development, whether it's a planned development for homes or a condominium property, everything other than the condominium units or the single family home and lots, that's going to be the common element. Now, what varies is in a common element for a condominium, it is owned by all the members as undivided interest. And in a homeowners association, it's owned by the association itself. But in either event, the common element is the property that is not owned by individual members. A community association is a term we use to refer to both condos, HOAs, and also to cooperatives. Condominium is really the property or condominium property. Sometimes we call it a condo, it's short. But we get confused sometimes that the condominium association is the corporation. It's the legal entity that manages and operates the condominium. The condominium itself is the property, both the units and the common elements. The DBPR and the division are related. The Department of Business and Professional Regulation, or DBPR for short, is part of the executive branch of the Florida government. It regulates many professions from barbers and cosmetologists, and relevant to what we're talking about today, community association management firms and managers. Also, one part of the DBPR is the division of condominiums, timeshares, land sales, and also includes homeowner associations. We call it in the industry simply the division. That is the group that arbitrates condo disputes, that handles election disputes for HOAs and condos, and regulates other forms of activities, mostly in condo, a little bit with homeowner associations. A homeowners association is the corporation that manages a planned community subject to a mandatory membership. We use the term throughout today of notice to members. What we're talking about there is going to be an official legal notice, meaning that it's posted where it's supposed to be posted on the property, or it's sent by mail or electronically for people who opt in to formal notice that way. We don't want that to be confused with actually notifying members by like Facebook or Instagram or maybe an informal email list. We use the terms owner and member pretty much interchangeably, and this is why. If you own a condominium unit, or if you own a home in a planned community, you are automatically a member of the condo or homeowners association. So for all intents and purposes, they mean the same thing. Now, if you have a corporation or a trust that's the owner, then the representative that will act as the member is going to be the human being who is designated to be the representative for that ownership entity. A special assessment is just another type of mandatory charge. The difference is it's not an anticipated charge. So if you have your assessments that come out from the adopted budget and you run short, there's some improvement that needs to be done, something that wasn't anticipated, and you are charged an irregular payment, that's a special assessment. And the only thing that makes it special is you didn't plan for it. So those are generally not good things. And finally, what we call a unit or a home is really referring to what people consider to be their home. In the condominium world, sometimes they're referred to as units. I don't think anybody would ever invite somebody over to come have a cup of coffee in their unit, but a condominium unit is a home in a condominium. A home otherwise would mean your duplex, your townhome, your single family home, and it's the part that is part of that development that is not the common element. So if we look about one of the fundamental distinctions between condominium and homeowner associations, a condominium is created when land is subjected to a declaration of condominium. So that land is no longer owned in lots in the usual sense. You now have a special map, a condominium map, and what people own as units or private property are going to be the designated areas in that condominium survey. And what makes a condominium special is you can own property rights that don't touch the ground, that they can be in the air and they're just defined by that description. And so these things don't exist other than there's a statutory environment that creates them and a developer subjects it to a declaration. Now, in a condominium, the part that is owned privately is called the unit. But what about the other areas, the lobby, the parking lots, maybe the roads, the amenities? People generally think of those as being owned by the condominium association, but that's technically not true. In a condominium, all of the unit owners, all of the members have an undivided interest, and they're the true owners of the common elements. The condominium association acts as the representative, but when you buy a condominium unit, you're not only buying your unit, you're buying a share of the common elements. And in fact, that is reflected on the value of your home by the property appraiser, and you pay tax on that. It's a little bit different in a homeowners association. In a homeowners association, each individual owns their home and they will typically also own their yard. The roads, if they're private, or the pools, the clubhouse, any of those amenities, typically the stormwater ponds, those common elements are actually owned by the association as corporate property. So as a homeowner, you don't have any direct interest in the common elements like you would in a condominium. You own, as a member of the corporation, you have an interest in the entity, but the entity itself separately owns those items. Now, I want to move on from there into what we like to call the rules of the road. Here, what we're talking about is what tells you the do's and the don'ts. In other words, we're here today for a legal seminar. We're here to tell directors or just neighborhood leaders, what do you need to know so that as a director, as a neighborhood leader, you are following the law, you're doing what you're supposed to do, you're not breaking rules that you shouldn't, and you're making sure that your association is well managed, well governed, and compliant. So, what's the source of the do's and the don'ts? And the thing about HOA and condos is there's a whole lot of different sources of direction, and they're not always consistent. So, not only am I going to share with you where does the law come from, where do the rules come from, I'm going to explain to you how in our firm and how I suggest for do-it-yourselfers, how do you figure out how to make it all come together? So you're looking here on the slide of all the different sources of law. And the starting point is what we call the governing documents. Now, the governing documents vary a little bit between condo and HOA, but are generally the same. At the highest level, in effect, think of it like as the Constitution is going to be the Declaration of Condominium or the Declaration of Covenants. Sometimes they're called Declaration of Covenants and Restrictions and Easements, but the same thing. Those documents are going to be what really are the most important at the highest level. So as we go through the list of governing documents, the higher level documents are going to control. So if there's something that varies, and that often happens, that there's an inconsistent term between a document at a higher level and a lower level, the document at the higher level is what's going to control, and that's going to determine what you do and don't. So if there's something inconsistent, we have a clear way of determining which one governs and which one doesn't. And that's high to the low. The other thing is this. Many communities have amendments over the time. So later in time, in other words, an amendment that's later is always going to replace whatever preceded it. So if you're trying to get your arms around your community, what I always do is I take all of the documents, all the covenants or declaration and all the amendments, and I go through the earlier documents. And if something's been changed later, I put an X through it so I know not to jump down that rabbit hole before I realize that, oh, that section was amended, so it doesn't matter anymore. So the declaration, whether it's condo or covenants, that's going to be recorded in the public records of the county where the property is. All the amendments will be recorded there. The next thing that we have are the articles of incorporation. This is the document which creates or forms the corporation which becomes the homeowners association or the condo association. That's going to be filed with the Secretary of State, the Department of State, and will also likely be recorded, a copy of it in the public records. That document tends to be limited more to basic elements of a corporation. And then you have the bylaws, which will typically be recorded as an attachment to the declaration. And this is what tends to govern the operations in terms of when do you meet, when do you hold elections, those type of operational issues. So the declarations tend to have the do's and the don'ts that affect the use of the property. In other words, what your setbacks are, what the condo units are going to be delineated between your property and somebody else's, the easements, all the things that really affect the land and the property and the condo itself. The articles tend to be fairly minimal in terms of content, and the bylaws tend to have all the things about the operational side. Now, the next thing you have is if your declaration or your articles or bylaws, and most communities do, have a provision that says that you can adopt rules, meaning you, the board, and that the homeowners agree to follow those rules, then those rules also become a governing document. You're not allowed to just make up rules because you're a director. There has to be an authorization for rule making in the declaration articles or bylaws. Now, one type of rule that's very common in homeowner associations are architectural restrictions, what color paint you can have, what the roof can look like, landscaping, but that's really just a different type of rule. You may also have rules, for example, on what the hours are to use the pool, where you park vehicles, all those type of things. Likewise, the rules can be amended from time to time. And the last thing you have are what we would call board policies or directives. Those are just informal instructions, typically to your community association manager or amongst the board and officers regarding maybe you're going to meet Tuesday at 6, or maybe you're going to require that if you want something on the agenda, you do it 2 days in advance, that kind of thing. It's basically just standing instructions that don't rise to the level of another rule even. Now, declarations of condo and covenants are typically only amendable by the members. Articles typically require a member vote. Bylaws vary. In some communities, the bylaws can be amended by the board on its own. In other communities, amending the bylaws requires a membership vote. And almost universally, rules do not require anything but a board vote. Although, as we'll talk about a little bit later, it does require special 2 weeks notice to members so they know a rule is going to be adopted or changed. Now let's go back to the whole list of items. One of the things that you have is you've got your governing documents. And I talked about how do you reconcile if there's a variation between one governing document and another. But now we have laws. We have statutes, Chapter 718 for condos, 720 for homeowners associations, and other statutes. What do you do if there's an inconsistency between the laws, the statutes, and the governing documents? And there often are. Well, we're going to talk about first, is there an inconsistency? In many instances, you might think it's an inconsistency, but if you read the first words of the section, it'll say something along the lines of, unless the declaration provides otherwise, or unless the articles say something else. In that case, it's just a fill in the blank. So if your governing documents cover that topic, then the legislature says, no problem. You do it your way. It's your governing documents. We're just providing fill in the blank if the person who drafted or created your community didn't cover this topic. So you're not going to have a conflict on those. But there's another type of provision, and here's a good example. 720.3045, I just picked this one, but there's many others, has a preamble that says, regardless of what your covenants, restrictions, bylaws, rules, or requirements provide, this is what it is. And in this case, it's talking about you can't provide restrictions on things in homeowner associations' backyards, essentially. So what do you do here if you do have a restriction in your covenants that would be contrary to 720.3045? And I'm just using this as an example. There could be any number of restrictions. For example, you could have something about parking commercial vehicles. There could be something about cameras on a condominium, or hurricane shutters. There could be a number of different things where the legislature has statutes or laws that are different than your governing documents, where there's an analysis that we go through. And what it really comes down to is this. One of the precepts of the American Constitution is that our government does not have unlimited power. And one of the limitations on government power is they cannot, they being the government, whether it's federal or state, can't impair your right of contract. In other words, with some exceptions, if you have a contract in place, an existing contract, they can't pass a law that changes the deal after the fact because you made your deal, your financial arrangements based upon the law that was in effect when you made your purchase or created your development. So how do we analyze whether this applies or not? You have a statute that says one thing and governing documents said the other. Well, there was a case in Florida that told us how to do it. I'm going to walk through the analysis. Even though this case came up in the context of a condominium, the principles should be the same even in a homeowners association. One is that you look at when did the law take effect. So if you have, for example, a declaration of condo or association, declaration of covenants that was recorded in 1980 and a law was passed effective 2025, then the law came after your declaration. So we have to keep analyzing it. Well, let's do it the reverse. Let's say the law was adopted in 1980 and your community was created in 2025. Well, in that case, the law came before the declaration. So there is no impairment of an existing contract because when that declaration was created, and think of a declaration as a contract amongst all the owners. And you might say, I didn't sign it. Well, the way the law works is it says if you've got a declaration in the public records, when you took title to the property, when you bought it and took a deed, accepting that deed, making that purchase because the declaration is known, it's in the public records, they treat that as if you signed the contract. So that's why we think of it under contract law. So if the law was there first, the law applies. And if the law is different than your governing documents, you follow the law. But if the declaration was there first and the law comes after and there's a conflict, then it might be an unconstitutional law. But we need to go further. Let's go next step. The next step is, was there Kaufman language? And the reason we say Kaufman language is there was a case that involves Kaufman, and that's just how we think of things like Brown versus Board of Education, Gideon versus Wainwright. So we talk about them in terms of the parties that were actually in court, but then we refer to the principles that the court adopted by the name of that claim. Because when the courts adopt a legal principle, that principle continues to have life for others who have the same fact pattern, and it doesn't just apply to those individuals or parties. So what's Kaufman language? Kaufman language means that your declaration specifically provided that later changes to the law would amend your declaration. So most declarations will have language that says subject to the law or subject to the Condominium Act or subject to Florida law. That's not Kaufman language, because what that means is that your declaration is subject to the law that was in place then when the declaration was created. We're talking about laws that came about later. So this is the magic verbiage. It's going to be as amended from time to time. Now, it may also say including laws adopted after the date, but generally it's as amended from time to time. And the time to time means that from the very initial declaration, it was contemplated that the legislature and governor would change the law and that the new laws would supersede any provisions in the declaration, articles or bylaws or rules that were contrary. And if you have the Kaufman language, the new law applies. Why? Because your very agreement said it would apply. So there is no conflict. Now, what if you don't have the Kaufman language? You got to analyze it further. Is the law essential for public life, health, and safety? Because one of the exceptions that allows the government to add a new law or change a law, even if it's contrary to your contract, is if it's essential for public life, health, and safety. An example might be provisions to protect homes against hurricanes or storms, things like that. But what about what we were talking about earlier about regulating what people can have in their backyard? Probably not life, health, safety. What if we're talking about restrictions on commercial vehicles? Probably not life, health, safety. You might agree or disagree whether it's a good idea, but I think it would be hard to argue by the state that this was essential to government protecting people's lives. So if it's not, you go further. If it is life, health, safety, then the law probably applies. And not life, health, and safety, we have procedural. And I skipped ahead of that, so I'll go back one step. If the law is only procedural, then it applies. And procedural would be like this. Let's say you have a provision in your governing document that says that you can fine people if they don't follow the rules. That's a substantive right that you can be subject to fines. If the legislature said all fines are prohibited, that's not procedural. That's a substantive change, and then you would analyze it on the other reasons we talked about. If, however, the legislature did what they did that said, okay, you can have fines, but you have to go through these steps in terms of giving people notice that you're going to take legal action, giving them a warning before you file a claim of lien, before you foreclose. That doesn't change your legal rights. It just makes you go through some process. So if you're dealing with the procedure, that is also something you're going to be subject to, even if it's different than the procedures in your governing documents. Now, what happens if you have a law and after going through all the analysis, when was the law enacted? Is it Kaufman language or not? Is it substantive or procedural? And is it essential life, health, safety? Do you go through all that analysis and you go, no, 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 no? It may very well be unconstitutional. However, if you're going to challenge something as being unconstitutional, think about it that you're going to end up in a courtroom. If you've got a homeowner that pushes the issue, and that homeowner is going to say, look, they're breaking the law. And as a lawyer, I'm not a constitutional scholar. Chances are the trial judge is probably not a constitutional scholar. So what you need to keep in mind is it makes it a challenge to enforce because the judges are typically going to want to enforce the law that is on the books, that's in the statutes. And if you're going to oppose that, you need to be prepared to maybe take it to an appellate court, and that gets expensive. When it gets expensive, that means the lawyers are probably going to get a lot of money. And we may be happy, but then your homeowners may not be particularly happy. And so the point of that is, if you're going to fight something on constitutional grounds, you really need to decide, is it something that's worth fighting for? Is this something that is worth the expense? Now, I want to go back to the other sources a little bit. So we talked about the laws. So when we're talking about the laws, we're talking 718 and 720. But what I hadn't finished covering is there are other laws. Because you're a corporation, Chapter 617 and 607, which govern corporations, those laws apply. However, the way the statutes are written, if a subject is covered in 718 or 720, then you can generally disregard that topic in 617 or 607. But 617 or 607 do apply where there are areas that are not covered by 718 and 720. There are also other statutes, such as environmental statutes, restrictions on solar might be covered, statute of limitations that are elsewhere. So we're not limited to just these sections. Then the other areas of law that we look at is the division of condominiums, timeshared mobile homes. They have rules that they promulgate. For example, how do you do a recall petition? But they also have a dispute resolution called arbitration. It covers election disputes for condos and homeowners associations, and it covers many other areas of disputes for condominiums. It's broader. And so we look at those opinions, not because they're binding, but because they give us an idea of how experts might interpret these provisions in terms of getting an understanding. Also, the DBPR, we had said earlier, they regulate your managers. So there may be things that you say to your manager, I want you to do this or not do that. And the manager may say, hey, I'm regulated by Chapter 468. I am required to attend a certain number of meetings. I'm required to do these other things because I'm licensed and I want to protect my license. And finally, when parties can't resolve their dispute and they go to court and the trial judge issues a ruling, and then the party who didn't win takes an appeal, and the appellate court issues a written opinion, whether it's a district court of appeals or a Florida Supreme Court, we have two levels. Those opinions are not only determining the dispute between those parties, but the interpretation of the law that is issued by that court becomes enforceable by anybody else who has the same situation. So it applies going forward and it becomes precedent for future court decisions. So we have to look at all those areas. So when you ask what you think is a simple question, I hope you have a little sense of why the answers sometimes take a while and may be a little bit complicated. Now, one of the things I would be remiss is when we're talking about the laws, is to tell people about the process. And I feel like I need to share it. If you're as old as I am, we made the Saturday morning watching horrible, shameless cartoons a little bit more educational because they used to have Schoolhouse Rock on the breaks. And one of the Schoolhouse Rocks among Lolly Lolly and Get Your Adverbs was my favorite was I'm just a bill sitting on Capitol Hill. This is how Florida works. We have a bicameral legislature, which means every idea starts off as a bill, and one of the legislators says, I want to make a change or create a new law, and they put it in bill drafting, and it gets written up. And then that bill gets assigned to committees, and it's heard by committees. And if it passes all the committees, it goes on the floor of either the House or the Senate, and it goes to the other body, and it goes to the committees there. And ultimately, if both the Senate and House pass the same bill, it goes to the governor and becomes law. So very similar to the way it works in Congress. The legislature meets every year. In even years, it meets in January. In odd years, it meets in a March because they have time for the elections. And it runs for 60 days. But the committee meetings usually start the preceding calendar year. And so what I always encourage people to do is get involved early because by the time the session starts, there is often a limited opportunity to affect change and have input. So as we sit here now, bills have already been introduced and you have the ability to find them. If you go to these websites, you can look up a topic or a statute or chapter like 718, 720, see what bills are already in the tank, in other words, in the pipeline. And you can see which legislators are going to be on the committees to hear it or introduce it. And you can get your input. Hey, I think it's a great bill. Boy, this is a terrible bill. Let me tell you why. Or I have my own ideas. And the reason this is important is when the law's passed, we're all going to sit around and talk about them and say, why did they do this or why didn't they do that? But there's such a great opportunity to follow the process. It's not like when I was a young man and I had to drive up to Tallahassee and you had to be right there to figure it out. You have the opportunity from your own living room to look this up and to keep track of the laws that are coming and to lobby your legislature and let them know. Because the one thing that happens is they're always going to hear from a disgruntled homeowner, but they don't hear enough from the people that are trying to make the system work, whether it's professional management or the community leaders who are volunteering their time to protect their communities. If you do go on the site, you'll not only see the bill, which will show you in language where they strike through existing text and it's underlined if it's an addition, but you can also see an analysis and you can see which committee or committees are going to have hearings on the bill so you know who to reach out to. So I want to move from that area to the duties of a board member. This is, if you're going to be on the board, you're going to be an officer, what do you got to do? Well, I used to say you either have to be a hero if you're a great board member or a villain. Now I say you be a hero or a criminal because if you do not do what you're required to do, there are actually criminal penalties that may apply for serving on a board. Some of the duties you have as a director are very specific. Others of them are general, such as follow and protect your declaration and to be a fiduciary. So let's give you an example of a very specific duty. One is spend 4 hours with us, become educated. You need to take the 4-hour certification within 90 days of getting on the board. You got to renew it every 7 or 4 years, depending condo or HOA. And then you have annual continuing ed requirements of an hour for a condo and 4 to 8 hours for an HOA, depending on how many homes in your community. Ansbacher Law and Ansbacher Education offer all these credits. We don't charge. It's part of our community service, and we hope you'll take advantage of our other programs. When we're talking about other very specific duties, you're going to hear from my colleagues. For homeowners associations, you got to keep track of the Marketable Record Title Act. So stay tuned for that. And for condominium associations, you've got to keep compliant with the milestone inspection and structural integrity reserve requirements. So these are very explicit that tells you, as a director, you must do this or you're in breach. But what about the general duties? Acting as a fiduciary. For those of you my age, I always like to say, if you do what Mr. Rogers would do, you're not going to get in trouble. And that was always a good guidepost for maybe people who don't remember Mr. Rogers' Neighborhood. I'll give you the legal side. Remember, I talked that 617 still applied to condos and HOAs. And here's a good example, because it's telling you as a director, what do you have to do? You got to act in good faith. Well, what's good faith? Let's turn around. It means don't be in bad faith. What's bad faith? I'll give you an example. Somebody cuts you off at the parking lot at Walmart and you're steaming mad. And the next day they're in front of you as a applicant for architectural approval for what they want to do. And you're still steaming over that parking space. I think that's bad faith. I think good faith means you don't let extrinsic issues, prejudices, personal gripes, things like that affect you and how you handle your governance, how you handle your position. The next one I think is really interesting, because in most of the times in law, we talk about acting as a reasonable person. Here, they're telling you as a director, you got to be more than reasonable. You have to be prudent, because it's not the same. Let's say we're talking about the funds of the association. Remember, you didn't get them voluntarily. You made people pay it or they could lose their home. You can't invest that money the way you would yourself. You can't do cryptocurrency. You can't go invest in the stock market, because you have to act as a prudent person. That's why we see CDs. Likewise, if you're talking about insurance, there are certain mandatory insurance requirements you hear about, but even what's not prescribed, you need to act as a prudent person, which means you should be really carrying insurance inappropriate. So it's telling you, be cautious, be prudent. And then the last one is you need to act in the best interest of the corporation, which means you cannot put your personal interests ahead of the corporation. Now, can you benefit? Sure. If the community is a better community, your property values goes up, you can benefit just like every homeowner, but you can't make decisions based upon just your benefit. If all the buildings need a new roof and you're in building 7, you just don't re-roof building 7. That's a good example. But now, when you're dealing with condominiums and a homeowner association, it involves law, it can involve engineering, it can involve HR issues, investment issues, accounting issues. Very few of us have that broad range of expertise. So how do you carry it out? How do you act in the best interest of the corporation if you don't have that expertise? And what it says you can do is you may rely upon others if you reasonably believe that they are competent. And it talks legal counsel, accountants, and others. Now, picking those parties means that if they give you bad advice, you're still not in breach of your duties if you rely upon it. But you do have a duty to be careful in how you hire them. If the person who is valeting your card says, oh, by the way, I picked up a law degree, for mail order, probably not the person you want to hire and rely upon. So that's your duty, is to vet and make sure that people are experienced, that they're qualified, that they understand these things. And then you are entitled to rely upon them. And hopefully they're giving you good advice. But even if they don't, you're still not in breach of your duties if you're relying upon what they guide you. Now, one of the things that comes up is people are concerned that I don't want to breach my duties. I'm not going to do anything. But the statute of limitations means this. If you don't act and time passes, that can essentially be an act. And for example, with this, there's a 5-year limitation on contracts, which applies to most covenants and rules. And there's a different limitation, 4 years, for construction defect claims. And those are the ones you're going to deal with most in a condominium or HOA. So how does it apply? For the 5-year limitations, let's just say you don't enforce your assessments and somebody is now 6 years delinquent. Well, that's essentially the same as voting to waive that 6th year, because once a debt is over 5 years old, you can't collect it anymore. Another example, somebody paints their home pink, you let it go. You're not concerned. 5 years happen after that home is painted pink. Somebody can prove it through Google Earth. You can't enforce that covenant against paint color anymore. Okay, not terrible. Second home is painted pink. third home, fourth home. At some point, that's considered a waiver, and everybody can paint their home whatever color they want. How's that going to affect your property values? So you never voted, hey, I vote to approve a pink home. But if you allow the pink home to sit there more than 5 years, that omission becomes commission. When we're talking about construction claims, and I do a lot of construction defect claims, whether it's your initial developer improvements or if you do a re-roof or a new pool, something you do later, it's a very tight timeline. You have 4 years from when the certificate of completion or occupancy is issued to bring a claim. If it's hidden, in other words, you can't observe it. There's no even signs of water stains. For example, if you see water stains, you may not know it's a roof leak, but you'll notice. If it's a hidden defect, you have 4 years from when you discover it or should have discovered it. However, in any event, even if it's hidden, you have 7 years from when it is certificate of occupancy or completion. Now, for condominiums and condominiums only, defects which occur prior to turnover, the clock starts at turnover. For HOAs, the clock starts when each building is CO'd. There is no tolling, there is no delay. So by the time of turnover, many of the claim periods may have expired. So as an ordinary prudent person, which is what you're supposed to be, you should all know your statute of limitations. If you don't, that's your homework. Figure out whether they've expired or not. If they're not, you should be talking to your lawyer and manager now over whether it's too late to preserve your rights and if you have a claim. And here's the issue. If you don't know, you should have an engineer, not a home inspector, an engineer look at your property and guide you with the help of a lawyer, because you don't want to find out there's a problem after the claim period has expired. If you do not act as a fiduciary, what's the risk? You could have personal liability. It means you could be responsible. Now, the good news is there is broad immunity if you're an unpaid volunteer. And we're back to 617.0834. In general, you are not personally liable for money damages. In other words, you might be sued and the court compels you to meet or do certain things, but you're not going to be liable for a money judgment, except, let's go through it. Even if you fail in your duties, even if you're negligent, one, you break the law, you steal money, you shred records that you shouldn't shred. Let's go to the next one, improper personal benefit. Example, you do a contract with your own company and you don't go through the conflict steps and you put money in your pocket. Another example, and this is a crazy one we had, is we had a director who actually usurped the gym and said, this is mine, it's mine only for my private property and nobody else can use it. That would be an odd one, but something like that. And the last one is that you act recklessly. So what's the difference between making bad decisions or being negligent, in other words, not prudent, and reckless? And they give us guidance. Reckless means you act or you fail to act, could be either, with knowing disregard. And what does it mean? It means it's known or obvious. And what is known or obvious? That your act or omission doesn't make it possible, but highly probable, not certain, but highly probable that there would be harm from such act or omission. So when you hear somebody talk life, health, safety, your engineer says, hey, this building is dangerous, you need to start thinking personal liability. So let's go into the last topic I am going to cover, which is board meetings. Now, board meetings often get confused because it seems like it's an association meeting. And I'll give you a little context. As a director, the law looks at you as kind of like a local government. Sort of like the school board or the city council or county commission. Why? Well, you have a taxing authority in the sense that you can assess people's homes. And if they don't pay it, you can take their home. You have rules that you can force and actually go into court and get court orders for people to do or not do things. So you have a lot of power and authority, and you're a representative. You are elected or you're appointed to represent your constituents, who are the members of your community. And because of that, the law follows a similar process to how they want local government to operate. Because you're spending other people's money, they want you to do it where the people who you are representing can see what you're doing and they have the input into the process. So while it's a board meeting, your members are invited to the meeting, so they can watch and see and hold you accountable, but also so they have the opportunity to give you their comments. You don't have to follow them, you have to listen to them. You don't have to do what they say, but they have the opportunity before you make decisions on their behalf, before you spend their money, to say, I think this is a good idea or a bad idea. That's the way the process works, in the same way any of us could go to the school board and tell them what we think. So the first part about being transparent is you got to tell them what you're doing. And how do you do it? You give them 48 hours notice of meetings. Now, if you are doing a rule change, you've got to give them 14 days because that's of greater concern. You must also post the agendas, and for condos, even include copies of the contracts you're thinking of entering. Those agendas and notices are what tell your members this is what the board is going to be considering, and you have the opportunity to weigh in. That way they can say, I'm interested, I'm not interested, and participate. Remember, this is formal notice, not just putting it on social media. When you're dealing with condos, there are even some more regulations that they want you to meet at least quarterly. Now, homeowner associations have no duty on how regularly they meet. They need to meet at least once a year just to organize. And in condos, they're even providing more input that you have to allow them to ask questions 4 times a year. Doesn't say you have to give answers, but you do have to allow questions. And it also requires the contracts to be posted. Lastly, for meetings, they have begun regulating video meetings, which became really, really common during COVID. So we're not talking about during emergency powers. That's its own special things, like when we're in a hurricane emergency. But condos, unlike HOAs, specifically allow video meetings, but there are special requirements. You must keep the recording for at least a year, and you must have a physical location where people can participate that don't want to use the internet. So in other words, you'd have to have like a screening room where there's a camera and laptop and internet, because people may not have that ability. There is no specific requirement for homeowners associations either authorizing, prohibiting, or regulating video meetings for now, but I anticipate there will be in the future, which is one of the reasons why we teach a combined class, because I anticipate that this slide in the future is going to be equally applicable to homeowners associations as well. For all associations, because you're doing the business of your members, you can't do it in private. You can't email your vote. You can't give another director your vote. You got to stand there and vote, and not in secret. The only secret vote you can do is election of officers. Other than that, stand there, stand proudly, vote, and be accountable. In most instances, a majority of the board of directors, in other words, you have a quorum is usually a majority of the board and the majority of the majority. So if you have a 5-person board, 3 is a quorum, 2 voting of the 3 carries the day. Not for all things, but most things. Now, if you have a 5-person board and all 5 show up, then it's going to be 3, not 2. Just do the math. Do you have to follow those Robert's Rules of Order? If your governing documents say that you do, many don't. And even if you do not have Robert's Rules, generally that process is so ingrained in the way we do meetings and such that most of us follow at least a watered down version of it. So let me walk through how a meeting is supposed to work. You may not do it this way, but you at least have to do some of it this way in terms of the voting and people's right to speak. You have to call to order. That's all. Next, you have to establish a quorum. If a quorum, meaning a majority of the board members, are not present, or with condos present in person or on the Zoom, there's no meeting. At that point, you say, hey, we're going to postpone the meeting for 30 minutes and try and get some people here, or the meeting's canceled. Number 2, the notice has to be given. If the notice isn't given, you're done. You shouldn't go for the meeting. Sorry, we forgot to give the 48 hours notice, meeting's canceled. Now, what if there's an emergency, a true emergency, not inconvenience, like the insurance is going to get canceled, the electrical bill won't get paid, something like that. In that instance, there could be a motion. I move that we meet, because it's an emergency, to address the insurance bill only. All in favor? Boom. You deal with the insurance and you adjourn. That doesn't allow you to talk about anything else. Next part, approve the agenda. Now, the law that says you have to post the agenda neither says you can or can't amend the agenda. You could certainly amend the agenda in terms of the order of matters. Put something first because the vendor's there and you want to get them in and get them out. That's not an issue. But can you add items to the agenda that weren't noticed? I don't know of any law that says you can or can't. It's unclear. What I do know, though, is if you wanted to add an agenda item like bylaws or adopt a budget that wasn't specifically noticed, you can't do that. But whether there are other incidental matters you can add or not, I would suggest you shouldn't. I don't know that there's a specific prohibition yet. Now, the next thing you typically have is approving the minutes or amending them. And remember, those minutes, if there's ever another legal dispute and it goes to arbitration or court, that's going to be what the judge or arbitrator is likely going to say happened, even if you were there and it wasn't exactly what happened. So if you're doing things where you expect there might be somebody bringing a legal claim, don't just perfunctorily approve it. If it said you did something, for example, we had a case where they called a charge, a cleanup charge, a fine, and that was dispositive when it got ruled on. And it was just somebody was a little sloppy with the language. So you need to look at those minutes, especially for things that might be a dispute, and just clean them up. Say, nope, I think this minute is incorrect. I move that we amend the minutes that these words be changed to those words. It's easy enough to do. Next thing you typically have, whether it's new business, old business, reports, your manager's report, your committee reports, your treasurer's report. And typically in the course of those reports, items will come up. Manager's doing a report, for instance, and says, hey, you asked me to go out and get bids from landscape contractors. I went out and got 4 bids there in your package. That's an action item, meaning they're now soliciting a vote. And that triggers the comment period. And how does it work? The item's introduced. You should not then go into discussion about how you feel about it. It's on the floor. The next thing that should happen is if any director has an ownership interest or relationship, we'll get into more detail, with one of the entities, you should disclose it. Say, hey, I've got a conflict for this reason. I'm recusing myself. Assuming there's no disclosures or they're given, you then look around as the chair and say, does anybody want to make a motion? Nobody wants to make a motion. You say, okay, for lack of a motion, next item. Now, what does that mean? It might mean people want to study it, look at it. It's nothing wrong, but you're not ready to act. Well, some people say to me, how can I make a motion before the discussion? Because the motion is kind of like playing pinball. You're putting the ball in action. So you might say, I move that we hire Acme Landscaper. That doesn't mean ultimately you vote for Acme. You may change your mind. You may amend your motion. It basically gets the ball moving. It's for discussion purposes. Second, now, once the motion's made, it's on the table, seconded, now you have discussion. See? And if the person making the motion gets persuaded that it shouldn't be Acme, it should be Green Jeans, then they can say, I move to amend my motion from Acme to Green Jeans. That's all. Now, how do you handle discussion? This, I think, is the best way after doing it 35 years. Let the members speak first. It's courteous and it makes it easier to delineate. So you'd say, okay, we have a motion and second. Before the board discusses, homeowners, does any homeowner want to speak on this topic? And please keep it to this topic, and you have up to 3 minutes. Let them speak. You might be kind to let them veer off course, but for the most part, anything other than things related to that topic would be considered out of order. When they finish speaking, you'd say, thank you, your turn is over. Now we're going to have discussion just amongst the board. And I find if you let them speak first, nobody's offended and give them that courtesy. Now the board members talk amongst themselves. When they're done discussing, somebody calls the question, you have a vote, and you move on to the next item. And that's rinse, wash, repeat for every voting item other than like motion to adjourn or those incidentals. Now you may have an open forum where anybody can talk about anything for 3 minutes at the beginning of the meeting and end of the meeting. In my opinion, that does not replace allowing the members the opportunity to speak on each voting item, separate thing, and finally you adjourn. Now, on the conflict disclosure, I want to come back to that. Managers have conflict duties to disclose, especially where they have affiliated entities. That is something that the managers have a duty to talk about whether a director, I mean, of the management company, a shareholder, your particular manager, in other words, or their officers, whether they have an interest in these companies need to be disclosed. And if they have an affiliated entity and the project is worth more than $2,500, they have a duty to at least attempt to get you bids beyond their own affiliated entity. And there's serious penalties to the management company if they don't do that, those disclosures. If you're going to approve a contract with a management company affiliated entity or conflict, that's one of those things. Remember, I said a majority of the board controls. In this instance, you need 2/3 vote for it to carry, and that conflict disclosure must be explicit in the minutes. What about director conflicts? You could have a conflict in a HOA or a condo. The rules are a little bit different. In an HOA, the director must disclose the conflict not just at the meeting, but 14 days in advance of the meeting. Now, how you do that when you don't necessarily know what's even going to be in the agenda, I don't know. The association is still allowed to approve it, and I guess that director's just in violation, but that's the law. Now, here's the issue. The disclosure needs to be disclosed not only for whether that director has a conflict, but whether a relative of the director has a conflict, or in other words, has a financial interest they're employed by. They own shares, they have equity in the entity that is proposing to do business with the association. So what does a relative mean? For condominiums, a relative is 3 degrees of consanguinity. For a HOA, there's no direction on what that means. And there is some real, more specific guidance for a director that is specifically in condo, it says the director can be present for quorum, but they should recuse themselves. There's no guidance either way for HOA. And in a condo, it specifically says there should be a 2/3 vote at the meeting, so it's more than a majority for a conflict of relationship. I can tell you Barry Ansbacher's advice is don't do conflicts. If you have a company, even if you're well-intentioned, you're just better off not doing business. But when it talks about an interest, there's no de minimis standard. So, for example, if there's a public landscape company and I own a mutual fund that owns shares in that landscape company, arguably that's a financial interest. If my nephew mows lawns in the summer for that landscape company, that's a financial interest of my nephew. So it really is very broad. It's a good intent. It may be overbroad. But when we talk about 3 degrees of relation, it's broader than you think, because it's not just you and your spouse and children. It's your uncles, your aunts, your nieces, your nephews. Anybody in those 3 degrees would be a proposed possible conflict that should be disclosed. Now, what about closed meetings? A closed meeting is a special type of meeting. That's when the board meets. It's quorum. In other words, if 2 directors meet and you have a 3-person board, that's a quorum. If you have a 5-person board, 2 directors can still meet and talk association business, but if the 3rd person shows up, now it's a meeting. Notices of meetings that are closed still must be given. And I know it's kind of like telling people we're having a party and you can't come, but the reason is that your members are still entitled to know, hey, they're not meeting in some secret stuff. They're meeting because there's a legal matter that requires discussion, and that is a lawful allowed purpose. So you give a notice. At the attorney-client meeting, you can't do it without an attorney-client. Some people call it, oh, we're meeting in executive session. Can't do it. We're meeting in a private meeting. No, it's got to be with a lawyer present, or at least by video. You cannot vote to approve or disapprove. For example, let's say there's a dispute over a landscape contract. At a closed meeting, you can't vote to terminate the contract. The way it works is, at the closed meeting, you can talk about what are the risks if you break the contract, what does a contract provide. You get legal advice and discussion, and then based upon, informed by that discussion, you then have an open meeting where you actually press the button to terminate or you don't. So the meeting there talks about it, but the action item of acting on that legal advice needs to be done in an open meeting. You can also, if you have direct employees, talk about personnel matters. Somebody has a drug issue, attendance issue, things like that in HR environment. That's the other exception. Minutes of these meetings should be kept, but those meetings are closed and not available as records until that dispute is over. And attendance at the meeting is limited to the directors, no members allowed, to the attorney and their staff, and anybody who's necessary. For example, if the treasurer it works with a finance committee member who's not on the board, maybe that person needs to be there. Maybe your accountant, maybe an engineer, and typically your community association manager. How is a closed meeting done? You call it to order, establish quorum, confirm notice, just like a regular meeting. If there's an emergency, same thing. Next, you want to do is you want to vote, though. This is special, that you want the group, you don't just want to announce, hey, this is a closed meeting. You want to vote. So the members of the board, the directors say, I move that this is properly a closed meeting and why. And the minutes should be sealed. That way, the minutes themselves say you were thoughtfully, intentionally following the rules, not avoiding it. The next vote you should have, if anybody else is there, like your manager, like your engineer, you should have a vote that explicitly says these people are here because they're essential for the meeting. So if somebody wants to challenge that confidentiality, you can do so. And remember, nothing discussed at a closed meeting should be talked about with anybody other than the attorney and the other directors. Even after you're off the board, that should never be discussed. Finally, your meeting is discussion, but you shouldn't be taking action items, and then you adjourn. Thank you so much for your time. I'm going to turn it over to my colleagues.
Okay, thank you, Barry. I will now be passing it over to partner Hannah Rulo, and she is going to start speaking about MRTA.
So let's get into MRTA. What is MRTA? MRTA. That stands for the Marketable Record Title Act. That is Chapter 712 of the Florida statutes. It's actually an entire chapter. And the purpose of MRTA was originally developed because back in the day, when title searchers would perform their title search for a property, they would actually need to go down to the courthouse, look through all of the official records of the county. And as you can imagine, the longer the properties existed, the more tedious and time consuming that process was. And so essentially MRTA said that if you haven't recorded your interest in property in over 30 years, then it lapses, right? There are a few exceptions to that, but it does apply to declarations, and it mainly affects homeowners association declarations because of the way that the deeds for homes, single family homes, are drafted rather than how condominium deeds are drafted. Why, right? This is why it doesn't apply to you condos. Theoretically, it could, but it really doesn't, because you would have to not have a transaction re-recording the interest in title within 30 years. And that's typically done just by the purchase or sale of a unit or even a transfer of a unit. So as you can see over here on Exhibit A, we've got a typical HOA deed. You can see that it recites the plat map and what lot of the plat that home is located within, but there is no reference to the declaration itself or the recording information for the declaration. If you look at example B, there's also another review of what that looks like, and you can see that it is actually highlighted to say except for the covenants and restrictions of record, if any. That will not usually preserve your covenants and restrictions. You've got to have something like A in order to do that. Now, condominiums will actually recite their declaration of condominium rather than cite a plat map. And so that's why their deeds typically prevent any expiration under MRTA, unlike HOA deeds. This is what the condominium deed that I was just describing looks like typically, and you can see that it actually recites the official records book and page for the declaration of condominium. So, why do we have MRTA? What is MRTA? Talked about this a little bit before, the purpose of MRTA, and it still exists today. Even though now we've got our official records for the most part available online, it's much easier to research them. And so, arguably the need for MRTA isn't as pertinent as it once was in our state. But nonetheless, it still exists, and you need to be very much aware of it, because if you have not re-recorded your interest in your restrictions over that land and since 30 years from the recording of your declaration, and that's a pretty vague date, if you will, MRTA is much more specific to that. It actually goes in a lot by lot analysis most times, but the best way to capture your covenants and make sure that you prevent expiration is actually to take the date of recording of your declaration, not the date it was signed, the date it was recorded. 30 years after that date, you will be expiring in general, right? That is when you want to have your notice of preservation recorded in the county prior to that 30-year deadline. So, why does this matter? Well, you HOA directors under Chapter 720 3032E actually have a specific annual duty to review your covenants and confirm that you're in compliance and that you are not subject to expiration under MRTA. And pursuant to that same requirement, you would need to move to preserve the covenants. Now, this is actually a pretty easy process. It can be done by board vote alone. And essentially, it's a notice that's recorded in the county records that says our association is still enforcing these restrictions. We're still bound by them. And pursuant to Chapter 712 and 720 of the Florida statutes, we're preserving our covenants here and now, and the public is on notice. So not only is this authorized preservation by MRTA's own Chapter 712, but there's a specific provision in there for homeowners associations and preservation of their declaration and any restrictions. So 720-3032 is actually where you would go for the information that you need for this preservation. Again, this is pretty easy, especially compared to what happens if you do not preserve, because this can be done by board vote. There does need to be notice of that board meeting. It has to be duly called. You need to record the notice in the public records, name all of the plats subject to those restrictions, list all covenants to be preserved, and send a copy of that notice to all members after it's recorded so that they're aware that this preservation has taken place and that their covenants and restrictions are enforceable. Why does it matter? Well, if you don't preserve your covenants and they expire under MRTA, then you can't even collect assessments. You can't enforce your restrictions at all. You can't enforce architectural restrictions. If any of you have ever heard about the famed pink house in the HOA, right? One of the houses that are painted pink. And why can they remain? Why is there this house that doesn't look like the others? And it's an older homeowners association. Typically, it may have been done while the association was expired under MRTA, and that owner took advantage of that. There are quite a few cases in Florida law about owners taking advantage of expiration periods under MRTA. And it can cause a lot of ruckus for the homeowners association, especially dealing with that house after the fact. And even the owner then going to sell that house because the subsequent buyer would need to bring that into compliance, at least arguably. And so that would be something that would need to be, maintained and listed on the estoppel. So take note of that if you are in that category where you were expired for a little bit and now you've been revived, which is the next topic that we're going to go into. So revitalization is what happens when you fail to preserve under MRTA. And it's horrible. I apologize for saying that, but it really is a tedious, time-consuming, horrible process. It requires the association to gain the written consent of a majority of the membership to bring the covenants back. So just imagine that. You've got to go tell your members, hey, those covenants that make you pay your assessments are expired and we can't collect on our assessments anymore. Will you vote so that we can assess you again? It's sometimes a difficult task. It takes associations years sometimes, especially if they're a larger association. So compared to preserving, this is something that you definitely want to avoid. So time consuming, so expensive to do this. And then you've got to submit it to the state for approval to revitalize your covenants. And then you've got to go record all of the new covenants. And that recording fee is especially expensive if you've got a lot of documents. So beyond that, all of the requirements of the state are very strict as far as it relates to who can sign the ballots, how the ballots are worded, what type of documents have been provided to your members, if you fulfilled the notice requirements for the revitalization process. In fact, there's an entire section, Section 3, under Chapter 720, its own section about revitalization, because this is such a lengthy, time-consuming process. So one of the things you've got to do is create an organizing committee of at least 3 homeowners. One of the funny requirements that you've got to do is every time you send out any communication from the revitalization committee, the organizing committee's names, phone numbers, and addresses need to be listed on that document. I have seen a lot of associations get hung up with the state for missing that on every communication, as you can imagine. Again, submit a complete text of the covenants to be revitalized to all parcel owners. You've got to send that out to the owners or hand deliver it. And that is an expensive cost of mailing or printing just all of the covenants. If you fail to include one of your supplements, one of your amendments that the developer recorded 45 years ago or whatever it may be, that could prevent you from revitalizing. And then you'd have to start the entire process over again. I mean, this is really just a difficult task. And I could go on and on about the funny stories that we've had with the state about certain requirements as it relates to revitalization in certain stances they've taken. For example, we had one association with documents so old, even when we had ordered a certified copy from the local county official records, that you could barely read the documents and what they said. And so our board wanted to retype the documents themselves and send out a retyped version of the same covenants, if you will, to all of their members in lieu of giving them a copy of that from the official records because it was so illegible. And so, cautious because of knowing the state's requirements here and having challenged them before, I contacted the attorney for the department that heads the revitalizations and posed this question. And the council said, how is your board going to retype the documents if they can't read them? So that was fun. And as you can imagine, we sent out the regular documents that were illegible. We got a bunch of complaints from owners about how they could not read the covenants, but that was what the state wanted us to do. And so that is how we proceeded, and they were revitalized. But things like that can really set you up for failure without even knowing it. And we see a lot of boards come to us that have previously attempted revitalization on their own and have been denied by the state. And so then they need to work with a lawyer. And I'm talking, this can cost like $50,000. It can get very expensive very quickly. And especially depending on if you don't have a plat for your association. Oh, older associations won't have plats. Some people didn't even know that, right? I was one of those people when I was a baby lawyer. We had a revitalization and the association had no plat map at all. And so they submitted a hand-drawn map, and we actually found case law similar to that with a revitalization of a community that had no plat map. And the state did accept that hand-drawn map, though that was not a fun process. And I would highly recommend submitting a plat instead if you are able to do that. All right. So now that we've gone through MRTA and the basics of that, revitalization, preservation, let's get into some fun stuff. This is elections, and this is for condo directors, HOA directors. And you'll see again with the green text noting that this is applicable to condos only. So let's talk about eligibility for directors. And again, this is for both HOAs and condos. So a board or election committee, if appointed, should decide on any eligibility challenges. Sometimes there's a question or a challenge by the owner as to whether that owner is actually, let's say, delinquent on their account payments to the association. They've missed an assessment payment. Both 718 and 720 call for ineligibility of that member as it relates to running for the board if they have failed to pay their assessments to the association. But because there's sometimes a question, that should independently be decided by the board or the committee. Because this is an area that's ripe for challenge. We see this a lot. We have, a couple associations a year at least that have election challenges go to the Division of Condominiums, and then will be brought in as their attorneys, obviously. Some associations now, a lot of them actually have our firm attend their annual meeting and election and assist the manager with getting that ready because of this being such an area ripe for challenge, in an attempt to prevent any challenges. So just know that this is something that is very important and it does come up a lot. Other things that could be a reason for ineligibility under the statute is if you had been removed by the Division of Condominiums previously as a director, so you had done something bad and they had removed you, or if you've been convicted of a felony. And take note that the word here is convicted, not alleged, not charged, not pled down to a misdemeanor. It is convicted of a felony. That also comes up a lot. All right. Now, elections are, in my opinion, really where condominiums and HOAs still diverge on the law today. The more time that goes by, the more the legislator is seemingly meshing these statutes to match one another, right? 718 becomes more like 720, or actually it's more 720 becomes more like 718 the more that time goes on. Here, though, elections, we still have a couple key differences. One of them being that condominium elections are conducted by secret ballot. Rather than with HOA documents, you can only do secret ballot if your governing documents authorize that. HOAs, as it relates to elections and meetings in general, are typically what do the governing documents say, where condominiums are more statutory creatures as it relates to the election requirements. HOAs, specifically, proxy voting is allowed. Condominiums can't have general proxies. Everyone keep that in mind, right? We're always talking about limited proxies. Elections are not required for either HOAs or condominiums if the number of vacancies equals or is lower than the number of candidates. So if you've got 3 vacant seats on the board and you only have 2 people running, there's no need for an election. Similarly, if you've got 3 open seats and 3 members running for the board, then they would all just get on the board. There's no need for an election. However, if we've got 3 vacant seats and we have 4 or more members running for the board, then there would be an election in that scenario. So the time of the election for both HOAs and condominiums should correspond with the annual meeting of the members. Quorum for elections for condominiums is 20% of the voting interest submitting the votes, and for HOAs, it's 30%, same as the quorum for the annual meeting. So keep that in mind. Online voting is allowed for both condominiums and HOAs, and I cannot rave enough about how much online voting has enabled our associations to make changes to their documents, to make their elections quicker and easier, to have less election challenges. It's been wonderful. We've had a lot of clients who are quite pleased with the online voting systems that they've then, chosen as their vendors. And I would highly recommend that to all associations to allow for online voting. You do need to do that by a specific board resolution that is authorized by both 718 and 720. So you want to make sure that you speak with your council and work with them in order to assure that you properly authorize online voting. But once that process is done and it is by board vote alone, then you're set to go ahead and proceed with online voting. So again, I really recommend it. And then finally, as it relates to a notice of suspension of voting rights, the association, both 718 and 720, so condos and HOAs, have the ability and authority to suspend the voting rights of a member that's delinquent with the association for at least 90 days. You need to provide written notice of that to the owner, though. You can't just not allow them to vote without notice of that to the owner at the election, right? So if you're going to do that as an association, you want to make sure that you're sending out that notice as soon as possible, to put the owner on notice. And hopefully that owner will even be encouraged to pay their amounts due to the association so that they can participate in the association election activities. So condos, this is where things get complicated, right? If we are doing the first notice and the second notice, all this green text, HOAs, this does not apply to you. This is only condos. So the first notice of the election needs to go out 60 days before the scheduled election. At that point, the unit owners may begin submitting their intent to be a candidate. The intent may be submitted until 40 days before the scheduled election. So everyone keep in mind that that is the deadline for when we would be determining if we have vacancies on the board that have been filled by, having an equal or lesser number of members willing to run. And at that point, you could not have an election or send the second notice for director meeting, because that would just be going into those directors would be appointed to the board, right? They would come onto the board automatically, if you will, from having fewer seats or fewer candidates than seats, and you would proceed with your annual meeting. So the second notice needs the agenda, the election ballot, assuming you're having an election, candidate information sheet, again, assuming that you're having an election, and then the agenda. And you've got to mail, deliver, or email that to owners entitled to vote at least 14 days before the meeting. Now, note that that email is only for owners that have opted in for official notice, their official address of record being their email address. That is not the same thing as checking the box that I want to receive emails from the management company. That is sending an affirmative acknowledgement to the association saying, in writing, I would like my email address to be my official address of record. And the association responding in the affirmative, we have changed your official address of record to be your email address. Here it is. So keep that in mind. I see a lot of people getting tripped up on that lately too. And I would really recommend, because not only does it reduce the cost by, having less mailing, and you can just do email, but if you go to your council, like we have a form I created that we give to our associations that allows the owner to opt in for email notification, and then you keep that form in your official records. And it just makes things a little easier, a little tidier, and helps the owners understand the process a bit more too. So HOAs, back to what do your governing documents say, right? The default is that your notice must be mailed, delivered, or electronically transmitted to the members not less than 14 days prior to the election and the annual meeting. 14 days is the standard, like, big meeting for HOAs, if you will, special meetings of the board, special membership meetings, assessment meetings. Your governing documents may extend that time period, so you want to double check to make sure that you don't have an extended time period. I see a lot of times that there will be a 15-day minimum in our clients' governing documents. And so if you're right on the edge of this 14-day thing and you're, say, 15, then oh no, you may actually be out of compliance depending on when you sent that notice. So be aware of that. So let's talk about vacancy removals and resignations of board members. Any vacancies may be filled by affirmative vote of a majority of the remaining directors. So if somebody sells their house in the middle of the year who's on the board of directors, someone dies, unfortunately, someone just quits the board, they don't want to deal with it anymore. That seat can be filled just by board vote alone. You put that on the agenda that you're filling the vacancy, and then the board would move at a duly noticed board meeting to appoint a new member to fill that seat. Keep in mind that there is automatic removal of the board members for certain conditions. For example, delinquency in any monetary obligation. Directors, if you are delinquent for any monetary obligation, then you are automatically removed pursuant to Florida statutes. Or if, again, you've got a conviction of a felony or charged with certain crimes. What crimes? It's like stealing and fraud and things like that, right? Crimes of dishonesty. Again, go to your counsel about this before you decide to proceed with automatic removal of any board member. As you all can probably imagine, this is another highly litigated area. It's a hot topic, and the directors that are being removed, when they're not, resigning, they're keeping their heels into the sand. They're typically ready to go challenge that, and then that will turn into a DBPR, matter that our firm typically handles as well. So just keep that in mind. Along those lines, let's talk about recalling board members. So can we do this by board vote? No, never. Not even if your governing documents say you can. That's not how it works, right? Under Florida law, in order to recall board members, a majority of the members need to, in writing, recall the board members. And similar to the revitalization statute I was telling you about earlier, the state is very tough when it reviews recalls. There are a lot of crazy requirements, rules that apply that in other areas in Florida law don't apply. For example, the division does not allow electronic signatures on recall ballots. There is quite literally a statute in Florida that allows electronic signatures to be considered legal and binding. I have no idea how that makes any sense, but that is what they do and enforce it. So as you may imagine, going into DBPR is not somewhere that we would usually recommend. We are typically directing you to go to the circuit court, but for recalls, challenges with elections, that is going to go to DBPR first. So let's talk about election challenges. Election challenges must be filed within 60 days of an announcement of results. If you are past that 60-day mark, then you are going to get thrown out of the division. That happens a whole bunch of times. And every time it happens, our firm says to the division, hey, this is the 61st day, and so you should dismiss the complaint. And there it goes. What is the remedy then? Then you go to the recall method. Because similarly, you can't start a recall within 60 days of an election, right? You got to give the directors a chance, at least 2 months, to do their work and perform, and then the division will look and say, okay, it's been long enough. Now you can recall them. So recall challenges will not be accepted again if there are 60 or fewer days when the next scheduled election occurs. So similarly to within 60 days of the election starting, if there's only 60 days left until the next election, the division will boot that one out too. And again, our firm will always put that up as a defense. That is, for some reason, the mistake I see the most with members, or people believing that there could be a removal of a director by board vote alone, right? That requires a specific process, and there are specific forms that are promulgated by DBPR for the recall process. All right, so this is the last section that I'll be handling before I pass you all off to Paula and the next attorney to take over. We're going to go ahead into membership meetings. All right. So member meetings are different than board meetings because they are for the membership, and it is where a membership vote is going to take place, or a meeting where the members have specifically called that meeting pursuant to Florida law or the provisions in their governing documents. So the membership meeting that most people are the most familiar with is elections and annual meetings. Those are membership meetings, but there are also special membership meetings. It may be that you'd like to do an amendment to your declaration. That would require a special membership meeting. It may be that your governing documents require approval by the membership for a special assessment. That would be a special membership meeting. It may be that your condominium is contemplating a material alteration. That would also require a special membership meeting. Along those lines, you need to provide specific notice of membership meetings. And this is where the 14-day default comes into play again, right? When in doubt, provide 14-day notice at least. Again, check your governing documents, talk to your attorney about this prior to noticing a special membership meeting or a membership meeting in general if you're not familiar with that process, because they do have different requirements than general board meeting requirements. So written notice must be provided to the members about any membership meeting for both HOAs and condominiums, mailed, hand-delivered, or emailed 14 days prior to the meeting, and posted in a conspicuous place in the community for at least 14 continuous days prior to the meeting. Condominiums, if you are required to have a website, then the notice and agenda posted on the front page of your website for 14 days, and 7 days of posting all agenda documents is also required. So you can have just the notice and agenda for the first 7 days of those 14 days, but by that seventh day, you need to have all documents. So if you've got any contracts you're considering, pictures of the material alterations, the ballots, everything that's included in that packet needs to be up 7 days before it. 718 specifically authorizes video conference meetings for membership meetings. Keep in mind that you'll still need to do the physical location as well with that. And you may use email if an owner previously consented, except for recall meetings, right? Again, recall meetings, very, very specific. They have their own guidelines. There's quite literally a recall guide that was promulgated by the state for that purpose. Okay, condos, you had some recent changes with membership meetings. So if you came to any of our classes about this before July 1st of 2025, then you would have learned something different. And you can see that we actually have the strike through language in there to show what is different here. This was a change that was enforced, if you will, through HB 913 and is now part of Chapter 718 of the Florida statutes applicable to condominiums. So membership meetings now must be located within 15 miles of the association or within the county. You're also authorized video conference meetings if there's also a physical location available. There is a quorum of the board that attends in person at that physical location, and the video is recorded and maintained as an official record. Again, this authorizes, it does not require video conference meetings. But if you do them, then you also have to have this physical location and a quorum of the board attending in person. The board must adopt online voting upon a 25% petition of the membership. So earlier I told you about how the board, by board vote alone can authorize online voting for the association. Now the members can rise up and say, hey, board, you didn't do it. We've got 25% or more of the members by written petition, so you must authorize online voting. Ballots, and this is not online voting, may be emailed to the condominium association. This provision is probably the most frustrating to me, especially as it relates to this secret ballot idea in 718. One thing that should be noted is that this statute simultaneously says that the owner that does that waives their secrecy, right, or their argument to secrecy. You're supposed to establish an association email where the ballots can be sent. I just really hate this idea. I see a lot of problems that can come from it, but this is now authorized, so everyone be aware of it. Again, this is something where I would say authorizing online voting would probably allow this to not be an issue for your association. But if you don't do that, then just note your members can email the ballots, and you can have those potential issues. Finally, there's a direction to the Division of Condominiums to adopt rules about the membership meetings. They haven't done that yet. As soon as they do, we will let you all know. Sometimes the division takes quite a while, as a lot of you are aware. So getting the numbers, how do we get the numbers for a membership meeting? You need to have a quorum, and it's not a quorum of the board. It is a quorum of the membership. So a lot of our associations, especially the larger associations, have trouble even getting quorum for a membership meeting. Some of our clients have never actually had a successful membership meeting because they've never obtained quorum. So quorum for the membership meeting, unless otherwise provided in the governing documents. For condominiums, it's a majority of the voting interests. And for HOAs, it's 30% of the voting interests. Let's get more into voting and participation. So condominiums voting must occur at a duly noticed meeting of the owners, and owners may take action without meeting when expressly allowed by the bylaws or the declaration. There's also some provisions within the statutes that allow the owners to take action without a meeting, such as recalls. You can serve a written petition for recalls on the association, or you can do a recall meeting. There's two different options there. So just keep that in mind. As it relates to owner participation for both condos and HOAs, all owners can speak with reference to any item on the agenda. The association can adopt reasonable rules governing the frequency, duration, and manner of participation, but no less than 3 minutes per agenda item for owners to speak. That's under Robert's rules. And then finally, the owners may tape, record, or videotape the meeting subject to reasonable rules adopted and promulgated by the board. Those are very similar, if not identical, to the rules for regular board meetings, so those should sound familiar to you. And with that, I will hand you all back on over. I do appreciate everyone being here, and I hope that you're having a wonderful time. Thank you so much.
Okay, thank you, Hannah. So that marks the beginning of our 5-minute break before I pass it on to attorney Alejandra Gonzalez to continue the rest of our course. So I'm going to set a timer for 5 minutes and then I'll be back on just so you guys can go stretch your legs. Thanks. Thank you guys for your patience. It's been a while, but we're almost halfway through. So now I'm going to present attorney Alejandra Gonzalez, and she's going to present the next few parts of the course.
Hi everyone, my name is Alejandra Gonzalez. I'm one of the attorneys here in our Community Associations team. I'm part of our Jacksonville office, and today we're going to talk about records. So let me share my screen. Perfect. So today we're talking about records. This tends to be a hot topic. A lot of our clients ask us a lot of questions about what's considered a record, what needs to be presented to an owner as part of a records request. So let's get into it. And of course, if you have any other questions that arise as I'm talking about this today, you can add them to our chat and we will try our best to answer them. So as you can imagine, in the most recent years, as technology begins to develop, there's now a requirement to post records on web, right? That didn't happen before. And now there's different types of requirements for both condos and HOAs. So for condos, if you have 25 or more units as of January 1st, 2026, you need to post your records on the web. That deadline is coming very, very fast. The end of the year will be here before you know it. So if you're on the board of a condo that has 25 or more units, we need to make sure we have a plan working to get all of those records on the web by January 1st, 2026. We kept here this 150 crossed out. The idea is that a few years ago, if you had 150 or more units, then you had the requirement to post the records on the web. As you can see, that has now drastically decreased from 150 to 25 units. That's a big, big change. They gave some wiggle room and some leeway for you all to get those records posted online because it is such a dramatic decrease. So for HOAs, please keep in mind that if you have 100 parcels or more, you need to post your records on the web by January 1st, 2025. Now that deadline has come and gone, so hopefully all of our associations here who have 100 or more parcels have already posted their records on the web by January 1st, 2025. And the reason that we want to point this out to you all is that we tend to see a lot of trends that HOA statutes tend to kind of follow what the condo statutes do. So as you can see, as I pointed out, the trend for condo associations was from 150 units dramatically decreased to 25 units. So this may be in line for our HOAs. We don't know what the future holds, but there is, like I mentioned, a trend that HOAs tend to follow condo statutes. So we want to make sure we're just planning for this in the future. If you are renegotiating or reviewing your contracts with your management team, you may want to just include in there some sort of some sort of way to deal with a potential web requirement, just to keep things in mind. Now, there may be some liability for knowingly and intentionally disregarding the redaction of protected information. The statute outlines what information needs to be redacted from the records, especially when an owner requests those records. Some things can't be shared with them. So there is now for HOAs, again, condos get green font and HOA specific rules get blue font. The HOA must now adopt written rules on record retention. So the statute is unclear exactly as to what degree of specificity you need to adopt these written rules on record retentions. So speak to your lawyer about coming up with some written rules on records retention. It can be pretty simple, or it could be more detailed depending on what you would like to do for your community. So HOA records, now there's a default retention date of 7 years, but please look at your governing documents. If your governing documents are silent as to how long you need to retain those records, then the default is 7 years. But if your governing documents, if your declaration specifically enumerates how long you're supposed to keep your records, and it's 8, 10, 15, 20 years, that's what you need to adhere by. There are also some criminal penalties for destroying, failing to maintain, or obstructing access to records with the intent to harm the association or further a crime. These are now some new criminal penalties that have been imposed on official records and the retention of them. We'll go over in detail what those criminal penalties may or may not be for condos and HOAs, but that is a new added section to the official records sections for both HOAs and condos. Now let's talk about some condo specific rules. There's now a duty to locate and restore missing records. Great. There's now that new duty that's imposed on the board of directors and the associations. But what does that actually mean? Locate and restore missing records. Does that mean that now you have to create minutes that happened a few years ago because the meeting minutes are no longer viewable, something happened? Does that mean you now have to go back in time and think of what may or may not have happened at a meeting on January 1st, 2020? Now you have to restore the missing records. Do you have to create brand new minutes? Do you have to reach out to previous board of directors and ask them for maybe they have those meeting minutes somewhere in their emails and their notes? It's hard to understand what the duty actually is and what is required of you, but there is now that imposed duty to locate and restore any missing records. Next, we have a duty to keep the official records organized in a manner to facilitate inspection. Now you may be wondering, what does that mean? Well, the statute is unclear. It doesn't specify exactly what is required and what is organized, what is an organized manner. Does that mean you have to keep your records alphabetically? Does that mean reverse alphabetical order? Does that mean you have to keep things chronologically? It's hard to understand what is required by that change to the statute. However, that is the new duty for the associations, for your condo associations. Next, you have to keep an inspection checklist, including documents not produced. So now for our condo boards, anytime you get a records request, when you facilitate that inspection or when you provide those documents online, you have to provide an inspection checklist. So there you have to list everything that owner asked for, and you have to create a checklist, right? This was provided to you, this was provided to you, and check it off, check it off, check it off. And if you don't have a document and a document was not produced to them, that needs to be stated on this inspection checklist as well. So just new duties to think about for our boards and their managers. Now you have to come up with this inspection checklist and provide that to the owner who's requesting those records. So this is a new change from House Bill 913. All affidavits that are required by Statute 718 is now considered an official record. So any affidavit that you have to sign and execute, now it's part of the official record. An example of this would be now you have to execute an affidavit when you receive the SIRS. That would be considered an official record, and you have to add that to your official records. Another thing to notice and point out here too is a website posting requirement. So if you have to keep, for example, your bylaws as an official record, and that needs to be on your website, if the board of directors decides to amend its bylaws and they hold the meetings, they execute the updated bylaws, now you have to post those updated bylaws to your website within 30 days or less. So keep that deadline in mind as the board continues to edit its documents, make changes, make amendments. There's now that new duty. As you can see, these are new duties and obligations that are imposed to the boards for official records. It's really important that we have to adhere to these requirements and try in your business judgment to fulfill those duties, even though there's a lack of instruction from the statutes from a legislature of what exactly they are requiring you to do. These duties are nonetheless imposed on our boards. Now let's talk about the criminal penalties for our HOA directors in regards to the inspection and copying of records. We, as I mentioned earlier, get a lot of inspection requests from our owners, and our boards and their CAMs tend to reach out to us and ask us for questions. What is an official record? What if I don't have this? Or anything like that. You have to keep all of that. You have to keep these criminal penalties in mind as you are getting these inspection requests. Now there's some real serious criminal penalties if any of this happens, right? And what are we thinking about? We're thinking about knowingly, willfully, and repeatedly violating this section with the intent to cause harm to the association or one or more of its members. If that happens, you're committing a misdemeanor of the second degree. If any person who knowingly or intentionally defaces or destroys accounting records, or who knowingly or intentionally fails to create or maintain accounting records that are required to be created or maintained with the intent of causing harm to the association or one or more of its members, you are now committing a misdemeanor of the first degree. And any person, director, CAM, anyone who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid escape, detection, arrest, trial, or punishment, they commit a felony of the third degree. These are very, very, very serious criminal penalties that are imposed on HOA directors, any person really who has anything to do with this. Please keep this in mind as you are receiving inspection requests. There are some serious penalties that the legislature has now imposed relating to records. Next, we have something very similar for our condo directors. This is for Chapter 718, and a director or member of the board or association of a community association manager who willfully or knowingly or intentionally violates this commits a misdemeanor of the second degree. Again, very serious penalties. And any person who willfully or knowingly or intentionally defaces or destroys accounting records, or who willfully and knowingly or intentionally fails to create or maintain accounting records that are required to be created or maintained with the intent of causing harm to the association or one or more of its members, commits a misdemeanor of the first degree. Very important. And a person who willfully, knowingly, or intentionally refuses or to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment commits a felony of the third degree. Really, really important, serious criminal penalties may be imposed. I just do want to note a change to the statute from last year that will now be applied is, It used to have this repeatedly language. Now that is gone. No more repeatedly. So just keep that in mind. That's a small change from the new House bill, to keep in mind. Next, we're doing a required record. So what is a required record? Again, we went over the default is to keep those records for 7 years, but check your governing documents, because if your governing documents, your declaration, anything like that says differently as to how long you're supposed to keep your records, then that's what the date you have to go by. 7, 8, 10, 15, 20 years. If that's what your governing documents say, that is what you need to adhere to. Otherwise, if your governing documents are silent, then the default is 7 years. So keep those two things in mind. There's a change in meeting recordings, and I'll touch base on that in a second, but meeting recordings, you have to keep those until the minutes are approved. For our condos, you have your question and answer sheets. That's part of the required records. Any affidavit that you're required to keep pursuant to statutes, to Chapter 718, you need to keep that in there as well. This is the big change that came from the bill. Before, you could record your minutes, right? You record your meetings, and once the minutes of that meeting were approved, then you could remove that recording from the official records. Now you have to keep the recording of any video conference meeting as part of your official records. Very important, new change. You have to keep the recording of that meeting as part of your official records. Now, this applies to everyone. The Board of Directors certificates, the certificates that you get at the end of today's class, you need to keep those certificates as part of your official records. Any inspection requests, contracts and bids need to be kept up for 1 year. Confidential records are part of that too, and everything in 718.11 Section 12 and 720.3034 needs to be part of your records. Again, 718 is for our condos and 720 is for our HOA boards. And again, keep in mind those criminal penalties that we just went over. They are very serious, and we need to keep all those records that are required in our official records. Now let's talk about condos. The condominium official records are listed here. There's a little figure here, and that designates the official records that must be posted on your online website. So what is an official record for our condos? Well, it includes developer documents, your governing documents, your association rules, your owner rosters, your insurance, your agreements, your leases, your contracts, your accounting records, your budgets, the financial report, election voting materials, your rental records, your questions and answer sheets, your SIRS, your inspection reports, bids, all affirmative acknowledgements, building permits, conflicted contracts, notices and agendas for all your meetings, educational certificates, meeting minutes, bills of sales, transfer of COA-owned property. Now, if you're looking at all of that, you're looking at this list, you're looking at this chart, and you're thinking, Alejandra, isn't that pretty much everything? Yes, that is pretty much everything. You are pretty much required to keep everything as an official record. And just in case that wasn't everything enough, there is this catch-all phrase here, all other written records. So anything else that is written is part of your official records. Just keep all of that in mind when you're getting these inspection requests. Okay, next. For our HOAs, what is an official record? Well, that includes your governing documents, your rules, your agreements, your leases, your contracts, your budgets, financial reports, insurance, conflicted contracts, educational certificates, the notices, the agendas, common area plans, specs, permits, warranties, your owner rosters, the bids, the disclosure summaries, the election and voting materials, all affirmative acknowledgements, accounting records, meeting minutes, all other written records. Again, that one also has that catch-all phrase. All of those are considered your official records for our HOAs, and please keep in mind that little symbol means that it needs to be posted on your online website as well. So that's a lot of the official records. Okay, next we have our official records retention chart. We just made a little chart for you all to keep in mind what's in official records for both our condos and for our HOAs, our boards here. For condos, keep in mind that you must maintain your records in an organized manner that facilitates inspection of records by a unit owner. Here we created a list of things that you need to keep forever, or 15 years, 7 years. So documents you need to keep forever for condos, that includes your developer documents, your governing documents, and your meeting minutes. Documents that you need to keep for 15 years. We'll talk about milestones and SIRS all in great detail in the later part of our presentation, but you can keep all of those for 15 years. And for 7 years, you need to keep all other official records, all other official records. And for 1 year, you need to keep your election, your voting materials, and your contracts and your bids. So for HOAs, for 7 years, you need to keep all of your official records unless your governing documents require a different or longer time. Look at your governing documents, determine what it says. If it's silent, it's 7 years. Otherwise, for 1 year, you need to keep election and voting materials and your contracts and your bids. Those are all the official records retention. We created that little chart for you all to keep in mind to kind of keep things straight. Okay, so as you can see, some new laws have come to be. The idea is to increase transparency regarding our HOA rules. That's what it seems to be that the legislature's goal is, increase transparency. So as of October 1st, 2024, all HOAs must provide existing members with a copy of its current rules and covenants, either physically or digitally. The HOAs must produce new members with a copy of the current rules and covenants. So let's take those apart. That October 1st, 2024 deadline has come and gone, and I hope all of you all sitting here today have complied with that. I'm not going to take a poll, don't worry. And for our HOAs, you must provide new members with a copy of current rules and covenants. So people who buy into the community, you must now provide them a copy of the current rules and covenants. The statute doesn't say whether that needs to be physically provided to them or mailed out or, knock on the door and give it to them. You can email them. There's lots of other options. It didn't specify exactly how you're supposed to provide those new members with a copy of the current rules and covenants. So that's just one that we have to keep in mind and adhere to, especially as the new members are coming into the community. Estoppel certificates. I do want to take some time to talk about this one. Estoppel certificates are the required form is in the statute, so you can just get it from there. No guesswork on what that needs to be because the form is just enumerated in the statute. There needs to be on your association's website where to request that estoppel certificate. It needs to be clearly designated on your website. You need to disclose any open violation of rule or regulations noticed to the unit owner. So I want to pause and talk about this a little bit. This is really, really important. If you do not disclose any open violation of the rule or regulation that's noticed to the unit owner, then you may be stopped from collecting, you may be stopped from enforcing, you may waive your rights about that violation in that house, that property, forever. This is really, really important. We have gotten some pretty simple violations, right? Please remove that dead tree from your front lawn, and that's something to add to the estoppel certificate if that violation is still open when that estoppel certificate is requested. But we've also gotten some very, very interesting violations, right? One of our owners in one of our associations painted their fence orange and added some white polka dots on it. So that was noticed. But if that owner requested an estoppel certificate and that violation was not noted on that estoppel certificate, it is very possible that you may be stopped from enforcing that violation if it is not included in your estoppel certificate. It is very, very important to keep everything that is an open violation to note it in the estoppel certificate, or you may be waived from enforcing it. forever, right? So really, really important. I do want to highlight some violations that are smaller than others, but you want to make sure you add every single one of them into this estoppel certificate. I cannot emphasize that enough. It's super important. The estoppel certificates are due within 10 days of request. The estoppel certificates are also valid for 30 days from the date of issuance. And there is a cap on what you may charge for the estoppel certificates. All of that is enumerated in the statute. Something that we want to make sure we point out and note for you all is special assessments. So if there's a special assessment that is contemplated within 30 days of that estoppel, but it has not been imposed by the time that you have to send out this estoppel, we always recommend putting a little disclaimer out there, making a note in that estoppel certificate. The board and the membership is considering a special assessment. The estimated amounts may or may not be X, Y, and Z. We always recommend for our associations to add in there, the board is contemplating a special assessment. There may be a notice special assessment within this time period. It's better safe than sorry to add that disclaimer in there when it comes to special assessments. That's just what we recommend all of our associations to do. Now, this isn't part of the estoppel certificate, but it is relevant to this section, so we added it here. If an owner asks for an accounting of their account, that needs to be provided to them within 15 business days. That is super important that we adhere to that deadline, 15 business days to provide that accounting that may be requested by that owner. So this is really important. As I mentioned earlier, estoppel certificates are something to take very, very seriously. If you look back into your estoppel certificates and you realize that maybe you didn't include an open violation or a special assessment that may or maybe not be contemplated, call your attorney, see what you can do to try to fix that. Just keep that in mind as we go forward. Okay, that ends our records section. Okay, the next topic is budgets. This is another one of our topics that a lot of people have a lot of questions about. And again, if you have any questions throughout the course of this section, you can post them on the chat and we will try to answer those questions at the Q&A at the end. So let's go ahead and get started on budgets. So budgets, there are different rules and a lot of distinctions between what is required in terms of budgets for our HOAs and for our condos. Again, I've said this a couple of times, but condo specific rules are in green and HOA specific rules are in blue. Okay, so for condominiums, notice and a copy of the proposed budget must be provided to the owners and adopted at least 14 days before the beginning of the fiscal year. So there's a lot to unpack there. Let's break it all up. So notice needs to be provided to all the members, all the owners, and a copy of that proposed budget must also be provided to those owners and those members. All of this needs to be adopted at least 14 days before the beginning of the fiscal year. So please keep that in mind, keep that deadline. You have to make sure that you adopt it 14 years, you're thinking about it months before. There's some timeline to work and to think about, so please make sure you're planning accordingly. So one of the big changes to the statute will affect 718.112(2)E. Listen up because this is new. So there is now a new requirement for our associations to simultaneously propose a substitute budget that excludes any discretionary spending if the proposed budget exceeds 115% of the assessments of the preceding year. Really important, really new. You basically have to simultaneously propose a substitute budget if that discretionary spending exceeds 115% of what the assessments were for the preceding year. The board now requires that substitute budget be presented to the unit owners for approval before a budget can be adopted. Board proposals in excess must include a substitute budget to exclude any discretionary expenditures. And now the majority of the voting interests can approve substitute budget. This is very important. That's a big change. Keep that in mind for our condo boards. For HOAs, different rules. You have to provide a copy to your owners, or you have to let them know, give them written notice that a copy of the budget is available upon request at no charge. So very different rules, not as strict deadline as condos. So keep those distinctions in mind as to what applies to you. Let's go over what a budget is, right? Essentially, it's a detailed listing of the estimated revenues and the expenses that are projected. So this would include the projected costs for maintenance. Maybe you are contemplating a new roof, adding new windows, adding new trees, anything like that. That would be part of what would be included in the budget. If you are having to increase the CAM services that you receive because of the new latest legislative requirements, maybe that's something that you have to add into your budget. All of those proposed amounts and budgets are divided up and paid for by the members. So it's important for the members to also be aware of this, have some input, provide some input to the boards for your budgets. And now it also would include reserves, aka capital expenditures, and deferred maintenance. All of that would be included in your budget. And please be mindful of the limitations on assessment increases and avoid any prohibited charges. That includes any transfer fees in 680.28, that statute. It's not enumerated in 718 or 720, but it does apply to our associations. Here's a sample of what a budget may look like for an association, just to keep in mind exactly the level of detail that you may need to keep for your budget. So it includes owner assessments, reserve income, late fee income, maybe you've got a guest suite, returned check fees, screening fees, services income, gate or key cards. If you're one of the associations that provides gate and key cards to your owners, put that in there. Violation fees, concierge loan, if that's what you've got in your association. All of that needs to be included in your budget, and you have to keep things very, very organized for your members. Here's, just like I said before, a sample of what a budget may look like. And all of it will depend on what you've got going on for your association. Reserves. So some reserves may be required for condos. Let me rephrase. Reserves are required for condos and they may be required for HOAs. Let's take condo first. We'll talk about CERS in detail later. We've got a whole section on CERS taught by one of our attorneys here. So, but let's just go over it briefly. CERS happen every 10 years. An engineer or an architect or a reserve specialist must do them. They must be fully funded. There is no waiver. There's also a temporary pause in reserve funding for 2 years immediately following milestone inspection. And like I said, we will talk about CERS in greater detail later on in this presentation. So for HOAs, they may be required. Look at what your governing documents say. We get a lot of questions about pooled versus straight line reserves. Please, please, please talk to your lawyer about them if you are thinking about making a change from pooled to straight line or the other way. It will really depend on your governing documents. Your governing documents may require a membership vote to change those reserves from pooled to straight. It may seem like it's easy to interpret if you may or may not need a membership vote, but they can be really difficult to interpret. Please call your attorney. This is an area of the association world where it may require different services. It may require an accountant, a finance person to help review this with you, and with the help of your attorneys. Things may be things may appear to be simpler than they are, but please contact your attorney. I'm emphasizing it because we do have some of our associations approach us with some of the issues, something that they are looking into. Okay, next we'll look at the annual reports and report requirements. So within 90 days after the end of the fiscal year, or as provided in your bylaws, you have to do the following. You have to prepare and complete a financial report of the preceding years and send it to the owners within 21 days after receipt, or no later than 120 or 180 days from the end of the fiscal years. Again, 120 for our HOAs, 180 for our condos. They're different deadlines for each of them, and that's from the end of the fiscal year. Financial report requirements, well, that depends on the association's annual revenue. Depending on what the annual revenue is for your association, you're going to have different financial reporting requirements. So please look into the statute to see where you fall in line there and act accordingly. However, if you have 1,000 or more units, you must audit. You have to audit. Can't get away from that one. 1,000 or more parcels or units, that's the figure to look out for. Now, members via majority vote can waive an audit every other year, but that's the cap. Every other year. You can't waive it for 2 years in a row or for 3 or for 4. You can waive the audit every other year if your members by majority vote choose to do so. Now, there is a downgraded financial report can be changed from the majority at a meeting to the majority of all voting interests. That's a big, big change, a big, big distinction. It used to be the majority at the meeting can downgrade the financial report, but now that has been changed to the majority of all voting interests may downgrade the financial report. And what does that mean? Well, really, it's changing it from a reviewed and audited financial statement to a report of cash receipts and expenditures that's outlined in the statute. That's a big change. Again, the majority of all voting interests have to vote to do that. For HOA, that's for condos. So for HOAs, it's still the majority at the meeting. Maybe we'll see that the HOA statute will require the majority of all voting interests later, but right now there is that distinction between HOAs and condos. Important to keep that in mind. Again, a big change from just the majority at the meeting to a majority of all the voting interests. The directors must also sign an affidavit of compliance. That's something really important. They need to sign that, and it should be part of the official records that we discussed earlier. Here is a sample financial audit. Most of the time, the CPAs, the people who are doing your financial audit, will reach out to us on their own. We'll get emails from them saying, hey, we have received this request. Can you please let us know any of the pending or threatened litigation claims or anything like that? We need to add it to our audit. We'll draft it up. We'll review it for you. We'll send it to them. Most of the time, the CPAs will send that to us just automatically without asking the board for permission. It's that serious. They want to make sure they're getting all of this right? That's why they ask us of any litigation or any claims or anything like that that may be pending for your association. This is brand new. It's the investment of condo funds. Like I said, this is brand new, and you changed the statute that is implemented as of this year. This is 718.11, subsection 16 of the Florida statutes. This is a new requirement to invest your condo funds. So it now reads, board shall, in fulfilling its duty to manage, operating, and reserve funds of its association, use its best efforts to make prudent investment decisions that carefully consider risk and return in an effort to maximize returns on invested funds. Now there's this obligation, this new duty to make some investments. Subsection B reads, an association may invest reserve funds in one or any combination of certificates of deposit or in any depository accounts at a community bank, savings banks, commercial banks, savings and loan association, or credit union without a vote of the unit owners. This is very, very new, very, very new. We recommend you reach out to financial advisors to fulfill this obligation. Some associations have already been doing this. We have one of our clients who have been doing this for years and investing their funds. So please watch out. This is a brand new duty that is being imposed on the boards. Reach out to your financial advisors, your attorneys to make sure you're doing this in the manner that the statute requires, and make sure that you're fulfilling your duties and your obligations as a member, as a board of director. And that is it for insurance. Again, if you have any other questions that may not have been answered in this section, please make sure you put it in the chat. We'll try our very, very best to answer those questions later.
All right, everyone, we've made it to the home stretch of today's presentation. We've got 3 more before we get to hot topics and Q&A. So thank you for being with us on this lovely day. So we're going to start off with insurance to kick off the last portion of today's presentation. So as you can see on the screen, what we are doing here is listing out the insurance policies that are required to be maintained by associations. I do want to point out that you can actually get a fidelity bond in lieu of insurance. We have found typically our associations, go the insurance route, but I just want you all to know that you are able to get a fidelity bond in lieu of these insurance policies. But as it relates to the typical insurance policies that are maintained by associations, the first one is directors and officers liability. It's often referred to as D&O insurance. And what this essentially does is it protects the directors and officers from any personal liability and protects any of those judgment calls made by them in their business judgment, for the betterment of the community, right? And so that's what D&O does. Now, the next 2, commercial general liability, often called CGL, and property and casualty insurance, typically those are the types of policies. And when we think of insurance, that's kind of what we're thinking about, right? With CGL, think of a slip and fall, right? Some sort of liability insurance, general liability insurance. And then when it comes to property and casualty, you can think of a lightning strike or a hurricane or even, a water leak. Those are the types of things that would fall under those purviews. Now, the other insurances that I wanted to point out is flood insurance. Now, typically, it's required for those who are located in a flood zone. I would say that we would recommend everyone in Florida should have flood insurance. I don't know how about you all, how it's been driving in the rainy season, but I think everywhere is a flood zone at this point, right? So that's another insurance that you would need to maintain. And then one of the newer insurances is this cyber liability insurance. Now, this kind of has come up with all the new technology and things like that. This relates to any potential cyber issues. So think of someone hijacking your reserves, right? This would be a situation where cyber liability insurance would get triggered, right? Now, something else I want to point out as it relates to our condominiums, the new laws that became effective July 1st of 2025, the replacement cost value must now be determined at least every 3 years at a minimum versus every 36 months, which was what the previous language of the statute says or contemplated. Now it is specifically every 3 years. All right. Now, in terms of our associations, we are mandated to purchase, like I said, fidelity bonds or insurance policies that cover, what does it cover, right? So it's going to cover all persons who control or disperse funds of the association. So who would that be? Think of it as people who can authorize, who are authorized to sign checks. So, your president, your secretary, the treasurer, or your management agent. And then what should it cover? The maximum funds that will be in the custody of the association or its management agent at any one time. Now, something that's highlighted at the bottom of the screen, very important to point out to you all, is that this requirement may only be waived. So the requirement to purchase a fidelity bond or insurance may only be waived if approved by a majority of your voting interest, which is a high threshold, right? Now, it's obviously not recommended. We, as you can see, big red letters at the bottom, waiver not recommended. And I think that that's kind of shown by the fact that you have to waive that requirement annually, right? So it's not something that's done in perpetuity. We voted on year one that we were not going to have insurance and we never have to do it again. No, every single year, your membership has to approve the waiver of purchasing policies or bonds by a majority of your voting interest. So like I said, waiver not recommended. All right, so as you can see here, we're just showing you what a typical application for insurance looks like. I'm sure you all have seen this before, but the reason why I want to talk about this is because disclosures are really, really important as it relates to your application for insurance. You do not want to fill out these applications erroneously, so please make sure to, consult your manager, consult your attorney if necessary. If it's something that you're not sure about, ask questions. The implications for filling this out erroneously, failing to disclose information, can be huge ramifications for the association. I used to work in insurance law, and what I have found from that is that an insurance company is always going to try and find a way to get out of coverage, out the ability to cancel you, to non-renew, right? And so don't give them ammunition for that. Provide the information that's necessary. So things to keep in mind, right? As you can see on the left side of the screen, this is something that you're signing as a director of the association. And it says specifically, the undersigned is an authorized representative of the applicant and represents that reasonable inquiry has been made to obtain the answers to questions on this application. You are representing that the answers are true, correct, and complete to the best of your knowledge. So you have to look into this information. And these questions on the right are, I feel, the questions that typically trip up our associations when they're filling out these documents, or can more often than not lead to the potential cancellation, non-renewal, or getting out of defense coverage because of these questions. So the first one is, any cancellations or non-renewals for the past 3 years. You have to disclose this information. They can find this out either way without you telling them or not. And so it just does not make sense to not disclose it. We have a lot of our clients ask us, well, excuse me, we have a lot of our clients ask us, well, I don't want to tell them that because then they might, quote us higher or whatever it may be. It's just not worth the potential implications if you don't disclose, it comes out. And so keep that in mind. Now, the next one, any uncorrected fire and or safety code violations. This is a major life safety issue. They will throw you out immediately, cancel your policy, because if you think about it, they are issuing a policy based on false information. And this could be a huge issue where insurance coverage gets triggered, right? If there wasn't, let's say, for example, you have an issue with something on the property. If there was never any safety code violations, fines, it would easily be covered. But if it comes out that you were aware of this particular violation for some time and you did not disclose that to your insurance, that's it. They will cancel you immediately. It's not a non-renewal, it's a cancellation. And then the last one is what I find to be probably the most difficult question to answer, because sometimes our clients kind of go back and forth, which, does it fall under this? Does it not? So enter all claims or losses regardless of fault. So that's important to note, regardless of fault or occurrences that may give rise to claims over the last 5 years. So that is a huge umbrella question, right? You're going to want to think about any pre-suit mediation demands that you've sent, that you've received, DBPR complaints, any owners that have threatened lawsuits. It's better to tell them, because we've had situations where you don't notify the insurance of this particular claim, or an owner who has been threatening a lawsuit for years, come to find out in the middle of a deposition, for example, that, oh no, I've been saying that I was going to sue for the last 3 years and you didn't notify your insurance until the third year, like I said, I have worked in insurance law, suing insurance companies, and they're always going to try to find a way to get out of defense coverage or cancel your policies. So just remember that when it comes to finding or filling this out, which this is kind of the one you're going to want to definitely ask your community association manager or your attorneys, what do you think would fall under this? Better safe to tell them everything, right? Right. So now, next slide, we just wanted to give you a quick overview of what an annual insurance audit looks like. These are typically pretty easy to fill out. If you ever have any questions, you can definitely ask your insurance agents. You can ask your managers. You can ask your attorneys to assist you as it relates to these audits. All right, so now we are at the next part of our presentation, which is milestone and CSRS. As we mentioned earlier, this is a particular portion of the presentation that is only applicable to our condominium associations. And so if you are an HOA, this is the time. You can go to the bathroom, take a stretch break, whatever it is. You're always welcome to stay and listen. Please don't sign off if you're an HOA, but ultimately this is only applicable to our condominiums. So, as I said, we are going to be discussing milestone inspections and CSRS, which is applicable only to condominiums. Milestone inspections are mandatory structural inspections, and CSRS actually stands for Structural Integrity Reserve Study. So this is a study of the association's reserve funds that are required for future major repairs and replacements. And the CSRS study is based on a visual inspection. Now, as you can see on the screen, it's very important to note that your failure to obtain your milestone inspection, failure to obtain CSRS, and fully fund CSRS reserves is a breach of your fiduciary duty as a board member. So it is not worth the potential savings you think you're having because you're not doing this. No, comply with the statute. This is required. And that ultimately is a pretty good segue into why. Why do we have to do this, right? We are required to do these inspections. We're required to have CSRS because it's ultimately a legislative response to the unfortunate tragedy at Surfside. This ensures that associations won't kick the can down the road when it comes to deferring maintenance, right? Or even, funding your future major projects, because at the end of the day, this comes down to the structural condition of your building envelope. This is a life safety issue. And always keep that at the forefront of your mind when you're dealing with these things, and remind your members who may be frustrated with increased costs and things like that. This is about your safety, our safety, and the building's condition. Now, so as I mentioned at the beginning of this portion of the presentation, the milestone inspections are mandatory structural inspections. If you need to know anything about these particular inspections, you're going to want to look at Florida Statute 553.899. This discusses who it applies to, when it applies, when it's triggered, all that good stuff. And like I said, these inspections apply to condominiums. It actually also applies to co-ops, and it is about 3 stories, habitable stories in height or more, right? So if you are an association with 3 or more habitable stories, you will be subject to the milestone inspections. Now, this is a recent change. It's important to point out, which is why I underlined it on the screen, but this essentially changes who the structural inspections and milestones inspections applies to, right? Because this time last year, the inspections were required if you were 3 or more stories in height. And so the way I would always illustrate this was saying, okay, well, listen, if the first floor of your building is a parking garage, and then, second and third are units, you would still be subject to CSRS as of last year. But the legislature changed that. So now it's only about habitable stories, right? So where you actually are living, where there are units. And so that's where it's going to be different. So that 3-story building that has a first floor parking garage now will not be subject to milestone inspections. And so, it does kind of take out a big, not necessarily, it might not be a big chunk, but it takes out a chunk of associations that normally would have had this applicable to them. Now it's all about habitable stories. Let's see. So these inspections come into play when your condominium is 30 years or older, based on when the certificate of occupancy was issued by your building department, right? Now, there are a few situations where it can be 25 years. That's typically related to your proximity to the coastline, but ultimately it's always going to be issued on the certificate of occupancy. Something I want to point out is that another change that occurred through the legislative changes this year is that CSRS, the deadline to do your CSRS studies and everything, was extended by 1 year. The deadline for completing the CSRS study has been extended to December 31st of 2025. A lot of the legislative changes this year, you'll see, they definitely are reflecting how much, this requirement has affected the condominium industry. And so you're going to see, and I'll try to point out as I go through the presentation, that a lot of these changes, it's very clear that they're trying to provide a breathing room to our associations, provide them some more flexibility and even clarity in certain situations. But ultimately, this is the general situation that we're in. This statute specifically requires, the CAMs and CAM firms to comply with the statute as directed by the board. All right, so now let's get into a little bit more of the details of these inspections. So who can perform milestone inspections? Architects, engineers, or the team of professionals working with an architect or engineer. Now, something that you'll see on the slide in the bottom left corner is a new change to the law that has to do with required disclosures. So any professional who is performing the milestone inspection needs to disclose their intent to bid on any resulting repair work. And if you think about it, that makes sense, right? Because the engineer performing the inspection would have a financial interest in finding more repair work in your building, right? So especially if they're going to get that work later on. So if the professional does not disclose their intent to bid before they start the inspection work, they cannot bid on the resulting repair work. So to kind of illustrate that, imagine I'm the engineer who is, hired to perform the milestone inspection. If I believe or think that I'm going to bid on the resulting repair work, I am going to want to disclose that to the association, to the board members, ahead of time, because let's say I don't. I perform the inspections, we've got the RFPs are sent out, we have, multiple bids, I send in my bid. If I didn't disclose it, I'm automatically disqualified from that repair work because it needs to be done beforehand. And again, that kind of makes sense. It goes in line with a lot of the conflict of interest stuff we were talking about earlier. This is just to protect the association, specifically because if you think about it, there is a financial interest there. So that's something new that has come out of the new laws this year. Now, this is just to kind of, give you an illustration of the statute I discussed earlier, 553.899, which governs milestone inspections. I want to point out that the legislature is essentially laying out its intent with this new statute, right? This was implemented as a public policy issue. As a result of the tragedy in Surfside, the legislature notes that it's all about saving lives, right? That's going to be more important than deferring maintenance, than potential costs, right? This is a life safety issue. And as I reiterate throughout this presentation, that is going to be something that you need to keep in the forefront of your mind when you're dealing with all the added responsibility, potential issues that come from this. But this is a life safety issue, and it's more important to keep our members, our tenants, our guests, our invitees safe. All right, so as I said, milestone inspection is a required inspection. And really, if you think about it, the only required milestone inspection is your milestone phase 1 inspection. And I'll get into phase 2 later and explain why phase 1 might be the only required inspection. The phase 1 inspection is a visual assessment of the structural conditions of your building envelope, right? As I mentioned earlier, this inspection is required once your building has reached 30 years of age. This gets triggered once the building department sends a notice that it's time to complete your inspection. Now, I will say that I'm of the personal opinion that it's better to be proactive rather than reactive, right? And the reason I'm saying that is because once you get that notice, there is a timeline or a clock that starts ticking in terms of when you need to get things done, right? And think about it. If the only individuals who can perform these milestone inspections are engineers and architects, there's ultimately a finite number of engineers and architects in the state of Florida that can do this, right? And so that's why I'm saying be proactive rather than reactive. You're going to want to start the process. You can kind of figure out when your 30 years is approaching, right? So by doing that work ahead of time, you can contract with time, not rushed, get your managers to help you determine when these need to get done so that you can get these individuals under contract. Because at the end of the day, and if anything, remember that failure to comply is a breach of your duty as a board member. And so if you want to come at it from that perspective, that's also something that you need to think about as well, right? So let's say the building department does issue the notice to complete the inspection. This is the time frame I was talking about. The inspection needs to occur within 180 days of receipt of that notice. That's not a lot of time. So imagine if you waited for that notice to be issued to contact an engineer, they could have 20, 30 condos that they're already working on, and you're not going to be next until 6, 7 months from now. There goes your 180 days, right? And so that's why I'm saying proactive versus reactive. Now, once that inspection is complete, the inspector will need to prepare an inspection report. And then based on their findings, two things could happen. And this is kind of why I'm saying, you might only be required to do your milestone phase 1. The engineer might do their visual inspection and say, you're good to go. You have met your requirements. You've completed phase 1. You have complied with the statute. There's no need to move to phase 2. But what happens if they say you are required to go to phase 2? So phase 2 is required when there is signs of structural deterioration to any building component. And later on, I'll get into the SIRS components, but that's essentially, what they're looking for and why you'd be recommended into phase 2. So for example, phase 1 inspection is happening, visual in nature. They're inspecting the property and they see on a wall some rust on part of your structure. You'd likely be recommended for phase 2 because they'll want to make sure that that building is structurally sound, right? Now the difference between phase 1 and phase 2, remember phase 1 is a visual inspection. Phase 2 can involve destructive testing. And part of the reason why is, going back to that rust example, you might need to chip at that portion of the wall to look and see if the rebar is intact, if it's, okay, or if things are going to need to be changed. And so that's the concept of why, phase 2 has destructive testing. You're essentially fully assessing the areas where there was structural distress and confirming that the building is structurally sound. So as it relates to timelines for phase 2, it's a little bit less stringent, but there's still a time frame. The inspector will have 180 days from the date of submitting that phase 1 report to provide a progress report and a timeline for completion to the building department. Now, a few other important things that we want to point out as it relates to SIRS and milestones is that SIRS and milestone inspections can be completed at the same time. They can often go hand in hand. SIRS, remember, serves as the funding mechanism for a milestone inspection, or can serve as the funding mechanism for the milestone inspection, as SIRS is based off of a visual inspection, right? Now, please also note that pre-suit mediation is available for a SIRS dispute. Pre-suit mediation is a 720 mechanism for HOAs typically, but now it's being offered to condos in specific situations like this, which we find ultimately tends to be much more helpful than the arbitration that's available under Chapter 718. Now, something new that was added this year is that now a board member is required to sign an affidavit that they have completed the SIRS study. This is one of those affidavits that we discussed earlier that's now considered an official record for condominiums, along with other affidavits that have been now required by the legislature. All right, so Oops, sorry about that. All right, so inspection reports. What does the inspection report from the milestone inspection require? The sign and seal of the signature. The inspector is going to want to or going to need to describe the manner and type of inspection. And then obviously, if there are any major signs of deterioration, the inspector is going to want to note that and recommend what repairs would be needed. And then if there are any dangerous conditions, the report will need to state that, and it'll state any items that require further inspection. So think i.e. milestone phase 2. Okay, so we often get asked, do we need to show these reports to our membership? And the answer is yes, absolutely, because you are required by statute. You actually have 45 days from the date that you receive a copy of the inspection report to give your members a copy of that report. And if you think about it, this is a good thing because in the event that you'll need to make substantial repairs in the near future, you're going to want to be able to show your owners why. For example, a special assessment may be needed to be passed, for example. And so it's always a good thing to keep your membership informed. That's really the way I look at it. And then, something else I want to point out is that you are required to post the summary of this report in a conspicuous place on association property and on your website. All right, so now the most important part, I think, sometimes, especially the part that, can be scary for associations because it can mean a lot of increased costs. But who is paying for this? Who is funding these repairs? Ultimately, you are, right? The owners will be paying for this, which is why it's a good thing that you show them these reports. Budgets moving forward need to be based off of CSRS. And something that I cannot stress enough, and if there's anything that you can remember from this portion of my presentation, is that owners cannot vote to waive or reduce funding for CSRS reserves. I want to repeat that again. Owners cannot vote to waive or reduce funding for CSRS reserves. Now, if you're an association that isn't subject to CSRS, you may be able to waive your reserves if it's approved by a majority vote of your membership. But this is, specifically as an association that is subject to CSRS. You cannot vote to waive or reduce funding for your reserves. However, as I pointed out, there are, kind of clues that the legislature is trying to provide us some flexibility, some breathing room, because now the law does allow for a temporary pause in funding for the 2 years immediately following the milestone inspection, right? So it kind of gives you, 2 years to try and get your bearings. Now, but that doesn't mean in perpetuity, right? It's just those 2 years immediately following the inspection where you get that pause. You have to have CSRS reserves in your budget. You can defer maintenance for items that at least have 25 years plus remaining useful life. And that can be found with your reserve specialist who's doing your study, or the milestone inspection individual can assist with, figuring out useful life. A lot of questions that we do get asked, or we had been asked about CSRS funding in the past, was kind of addressed with this new law change. One of the big ones is now it's, in the statute, CSRS reserves can be pooled. So not necessarily straight line reserve, they can be pooled without membership vote. And now codified, it can be funded by a number of ways. You can do it through assessment, through special assessment, or lines of credit, or even loans. And something I want to point out as it relates specifically to lines of credits or loans, a bank is always going to say, yeah, we can give you money, right? But something that I want to make sure that you do is make sure that you review this with association counsel to make sure, because sometimes your governing documents may say something different, or it may not allow you to get lines of credits or loans, in the same manner that's allowed in the statute. So just make sure that that's something that you discuss with your association counsel. All right, so what is a CSRS component? Now, as you can see on the slide, basically everything is a CSRS component. And a question we get asked a lot, specifically about item 8 on this slide, is, well, Emily, our declaration states that windows are a unit owner responsibility. So why would we need to fund that? Ultimately, it doesn't matter. When it comes to CSRS, experts, engineers, they've determined that windows are part of the structural component of your building envelope. And as a result, you must fund reserves for it. And if you think about it, like if you really think about how a window is placed within your building, it makes sense that it would be a structural component because it's, you know, a hole that in a pocket that's enveloped within your building. And so it makes sense why this should be a SERS component, but that's something that we get asked a lot. Another thing that I wanted to point out and kind of clues you into the goal of the legislature this year, I think, was to alleviate pressure on condos, is the change as you see on the last point on the slide. So a SERS component was also this catch-all, anything else that has a deferred maintenance expense or replacement cost exceeding $25,000. Now, as you can see on the screen, I, illustrated, it used to say $10,000. Now it's increased to $25,000, which I think, kind of signals the legislature trying to alleviate this pressure, right? So now the threshold is higher. Maybe a few things that would have been a SERS component that you would have had to reserve and fund for those potential issues now is not a SERS component and wouldn't necessarily need to be part of your SERS reserves. Okay, now to finish up this portion of the presentation, the requirements of the inspector. So as I mentioned earlier, an engineer or an architect or a team of professionals working with them must be the one that performs the milestone inspections. So now when it comes to SERS, you don't necessarily need one of those individuals to perform the SERS study. You can actually hire what's called a reserve specialist. There's plenty in the state of Florida. However, a lot of the individuals who are qualified to do milestone inspections actually can also do the SERS study. And so you may want to consider that when you're out there contracting, asking, can you perform the inspection and also perform SERS or prepare the SERS, excuse me. Now, that's not necessarily the case. You can have two individuals do it, have this reserve specialist, and then also have the engineer architect do the inspection, but it's just something to consider. Now, on this slide, as I discussed a little bit earlier, that they can assist you with this, is that this is an example of a formula that can be used to determine the useful life of a SERS component. And as I said at the beginning of this portion of the presentation, SERS stands for Structural Integrity Reserve Study, right? So the inspector will need to identify each item that was visually inspected and then state the remaining useful life of each of those items. And then based on those findings, they'll be able to provide the association with a reserve funding schedule, right? This can be used to create the association's budgets. Now, please note that now it's specifically required. A lot of the studies already did this, but now the study is specifically required to consider the funding mechanism for the SERS reserves. And that's something that, I just wanted to point out that changed as of July 1st of 2025. Now, just to kind of wrap this portion of the presentation up, I understand that this can put a huge burden on our boards. We've seen the crisis all over the state. But if you can remember that this was ultimately put in place to save lives, this is a life safety issue, and that we want to properly maintain our buildings. Just remember that. And when you have your, potential members that are upset about increased costs, you can explain to them, this is why we're in this situation and this is what we want. We want our buildings to be safe. And, you also want to maintain your buildings so that they can last longer, right? If you're continually maintaining your buildings, you're able to extend their life, right? And so that's just something that we need to remember when it comes to this, because I think that something that we're talking a lot about as it relates to SERS and milestones is this increased burden, financial burden on our associations. And so just trying to reframe why it is that we're doing this can help when you're talking to your membership or even yourself looking at the budgets, right? All right, so with that, we are on the last portion of our presentation before we get to hot topics and our Q&A, and that is disputes. So what are disputes? Disputes come in all shapes and sizes. It could be when the association is advising an owner that they have, a violation of a provision of the declaration, or they're doing something that they shouldn't be doing. It could also be when a member has an issue with the board, right? Or the manager, for example. So disputes ultimately go both ways. Now, what I'm going to be talking about on this slide is as it relates to the enforcement of your declaration, right? So you have several options for enforcement, but the main thing I want all of you to remember is that the goal here is compliance, right? So that's why we always recommend starting out with education. Educate your members on what is and what is not allowed. And that can sometimes, nip the particular situation in the bud because you're educating them, right? Compliance is the goal. So you can tell members, listen, this is what you've done wrong. This is what you're supposed to do under the declaration or chapter, whatever act is applicable to you all, 718 or 720. And typically this comes in the form of a courtesy notice, right? We are notifying you that you have violated this particular provision of the declaration. Please, do X, Y, and Z to fix it and come in compliance with the declaration. Remember, the declaration is a contract between the association and its membership, and ultimately there are certain responsibilities or certain things you can or cannot do, and that's what your declaration indicates, right? And so courtesy notices are not required under the statute, but we typically say that it's a good idea to do it because, again, the goal is compliance and education to ensure that things don't continue to happen repeatedly. Fines, right? Now, as it relates to fines, the idea is that owner, you've done this so many times, it's a continued violation, it hasn't been cured. So as a result, we're going to impose a fine of X amount of dollars for the violation. The same kind of goes into, the same concept goes into the idea of suspension of privileges and use rights, right? You can suspend use rights and privileges for an owner or tenant for a reasonable period, but something that I want to make sure that you all understand is that you can't ban owners access to the property, right? So for example, you can't say, well, you are suspended from using the guardhouse. Well, that's how I enter the association. So that can't be the case. But I think, think of maybe they've been doing things they're not supposed to, bringing glass to the pool when they're not supposed to, and now we are suspending your use rights to the pool. That could be, that's a good illustration of an idea of suspending use rights and privileges. So the idea has been, you've been so bad that, and after a neutral hearing, you're suspended from doing this, at least for 30 days. Now, the last part is civil action, which obviously is the attorney's favorite. Now, as it relates to condominiums, condominiums have a special ability for non-binding arbitration. Now, only a few disputes fall under that particular jurisdiction. It's lined out, or it's outlined in 718, but I will say, when it comes to the situation of where you're going to place this, I would talk to your counsel whether or not it's a dispute that needs to go to non-binding arbitration. But typically with situations like this, they end up in a lawsuit. That's why I prefer pre-suit mediation, which is a mechanism under 720. It's an alternative dispute resolution that only was available for HOAs originally. And now condominiums can opt into it for certain things. So for example, like I talked about in the milestone inspection portion and CSRS, you can actually use the pre-suit mediation mechanism for any CSRS dispute. So that's the idea where condos can use mediation. And if you think about it, the idea of mediation just makes so much more sense than arbitration. Arbitration is, one person or a panel of individuals, of arbitrators who are deciding who's wrong and who's right, or what they're siding on, or who needs to do what, right? Or needs to stop doing what. When it comes to pre-suit mediation, this is where both parties come to the table and they have a neutral third party that is going to try and help them come to a compromise, right? And if you think about it, the idea is that we're living in a community with our neighbors. And when it comes to a dispute, you're disputing with a potential neighbor. And so we are trying to prevent this from going into a lawsuit and try to resolve it amongst the parties. And I just think that helps more for the community overall, if we can get this, resolved in a place where both parties feel like they're being heard versus an arbitration, right? I will say that for our firm, 90% of the disputes that go to pre-suit mediation, they resolve at pre-suit mediation, which is, again, a great thing, right? Now, let's get into some HOA enforcement, right? Now, as it relates to HOA enforcement, there are new association rules that came into play as of July 1st of 2024. And, the main thing that I'm looking at is, the reasonable and equitable enforcement by your ARC and having to cite to the particular provisions for any denials, right? So you now have to point to the provision you're saying has been violated. And you used to be able to say, okay, well, it's against the general scheme of the community. And now you have to point to what the violated provision is. And personally, I think that it makes sense to have, a place where you can point your owner to. When it comes to general scheme of the community, that can kind of become a little bit subjective. And I just think that changing this, it's hard for our associations who've done it differently in the past, but generally speaking, I do think it's a good thing that now you have to cite to what provision has been violated and or what needs to be cured or anything like that. Now, it also amended the 2023 prohibition on violations not visible from the adjacent parcel or the front parcel, or the frontage of the parcel, excuse me. Now, I think it's easy to kind of illustrate this a little bit more by using an example. So it's not a violation to have a shed. Let's say you have in your governing documents, no sheds. But under this particular part of the statute, it's saying that, let's say you built a shed, but it's not visible from the front or adjacent parcel, and now included adjacent common area or community golf course. We're not really sure what not visible means, right? We always joke that, well, what if, you got on a ladder and you see the shed that shouldn't have been erected? It's contrary to the governing documents. Well, would that fall under purview of this particular situation? What does not visible mean? This is something that I think will need to be, discussed with your particular counsel with situations like this, but that's something that, we always like to point out. Now, in terms of hearings are now required at a minimum of 14 days from, issuance of that notice, but now there's a maximum of 90 days. So the idea is that basically this can't go on forever. You can't issue a notice and say you're going to impose a fine, for example, and not have the hearing for that fine within those 90 days. I'm going to do it 6 months from now. Well, that's just not really fair, right? We want to make sure that, we're doing it contemporaneously in time or as much as we can, just because, you want to feel like there is a beginning and an end. And so I do think it's a good idea. I don't think you should be sitting on these violations and having hearings way later than you normally would have. Something that I think is important to note is that if your violation that is at issue is cured before the hearing, you cannot impose a fine or you cannot impose suspension of use rights. And there are going to be particular, violations that I can think of off the top of my head that it's going to be so easy. You're never going to be able to impose a fine because it's easy to cure that violation. I'll talk about it a little bit later, but garbage cans. I mean, I'll just pull it right in. Or you're not picking up after your pets. Well, each different deposit by your pet, for lack of a better way to say that, would be, if you pick it up, technically you've cured that violation. So those are things to think about. Now, fines. This is basically us laying out what we think is the best process in terms of, potentially fining someone for a violation. The first thing you're going to want to do is review your governing documents to determine what constitutes a violation. Remember, you need to point to the provision. So it's not just because I don't like it. Or, as I said before, the general scheme of the community. No, now you have to be pointing to something that this was what you violated this provision. You're also going to want to establish a policy as to when to assess fines. Now, before I keep going, just know that this can also be considered, in terms of suspension of use rights. But I'm just going to use fines for this particular portion of the presentation. Now, so you're going to want to establish a policy, and the idea is that you want that because managers need guidance on what to enforce, right? Having something outlined specifically, it's just going to be easier for everyone. And really, if you think about it, it's going to be helpful for your membership as well. If they know that this is the process, this also, I think, helps with the concept of, or the potential defense of selective enforcement, right? If you just follow the same exact process for every single violation, you can't come in and say, oh, well, you know, you selectively enforced against me because you didn't send me a courtesy notice. You just went immediately to the fines, but you sent so-and-so 3 courtesy notices. Why, right? So that's something that, you know, is going to be helpful. You just streamline the process. You're going to want to establish a covenant enforcement committee or appeals committee. You cannot fine without having a committee. Now, we have found, and I'm sure you all have situations like this in your associations, no one really wants to be on it, or it can be difficult to get individuals on here, but sometimes changing the name of the committee can be helpful. So, you know, sometimes get creative. We've had, you know, compliance committee or beautification committee, things like that. Try to get creative to try and help your association, because remember, at the end of the day, the committee must be members of the association, but it can't be board members and it can't be anyone related to the board. So trying to entice people to be a part of this, be active in their community, sometimes can help by changing the name. And then ultimately, you're going to want to set up a procedure to ensure the proper notices before and after are provided in compliance with the statute. Now, just a little caveat that we want to point out as it relates to fines specifically and liens. And there is a distinction between condos and HOAs. So for 718, you cannot lien a fine on a unit. Now for 720, you can lien a fine, but it must be at least $1,000. And so if you have, let's say we're in collections and you're going to do a lien on the property for these delinquent accounts, if there's a fine on this particular debtor, you can't lien it or include it on the claim of lien if it's $900. You're going to need it to be $1,000 or just not included on the lien. And then something else that we want to make sure that you're aware, which I think we've already covered, but just to reiterate, is that the notice to impose a potential fine, you need to include on that notice the description of the alleged violation. You need to include the specific action required to cure the violation. So think about like pressure washing your roof, right? You need to pressure wash your roof, but let's say there is a situation where you end up having to patch your roof. If you're not able to patch the roof in a situation where it matches the rest of the roof, that might require an ACC application to re-roof, right? And so for things like that, the specific action could be do this and that's it, or it could be do this, and if that doesn't work, do that. That's something that we try and provide to our associations because it just helps guide the member on what they need to do to ensure that this doesn't happen again, right? And then you also absolutely need to include the date and location of the hearing. Remember, you know, the time frames of 14 and 90 days, but now a hearing is required for HOAs. I would not be surprised if condominiums are not too far behind. It didn't happen in this newest legislative update, but you know, something to consider. We have condo associations that are already starting to do it, but up to you all. All right, so we wanted to point out as it relates to enforcement for holiday decorations, the laws that went into effect last year now indicate that you cannot fine a member for having holiday decorations until you give them at least 7 days notice to take down the decorations, which, okay, fine, that makes sense. But the problem is that the legislature really didn't provide us much guidance. What does that mean? What is a holiday? So just to kind of illustrate that, on the slide, you can see a list of the legal holidays in Florida. Now, in the statute, it doesn't actually say legal holiday decoration, so who knows, but this kind of gives us a stepping stone, right? And the way we look at it here is that I'm sure all of you can think of an owner who has is going to want to try and use this to their benefit to keep lights up all year round, right? So think about it this way. Okay, I send out a notice after January 1st. You've got your lights up. You've got, they have it January 1st. On January 7th, we send out the notice and they say, okay, that's great, but these are up for, the celebration of Martin Luther King's birthday. Then you send another one. Oh no, well, actually this is up because of this, or it's, as you can see, interesting holidays that we have here in Florida. We've got Confederate Memorial Day, or I have it for Labor Day or Thanksgiving, whatever the case may be. So something to keep in mind when you're looking at issuing violations for these things, because there is a potential argument to be made that, no, I don't have it up for that anymore. I have it up for something else. And so we just put up a little illustration here on the slide of Abraham Lincoln on a flamingo, which could be coming to an HOA near you. Imagine being the neighbor across the street from that, right? So now there's a few more things that we wanted to point out as it relates to HOA enforcement. We're finishing up the end of the presentation, but the idea is that one of the bigger changes that happened last year in terms of HOA enforcement is that HOAs cannot enforce parking restrictions unless the vehicle meets the definition of a commercial vehicle, which, just to give you an idea, the definition of a commercial vehicle is that it weighs 26,001 pounds, which is the equivalent of about 13 tons. And just to illustrate that for you, a school bus is 12 tons. So I'm not really sure what type of vehicles we're going to be able to enforce against, and what type of vehicles are going to be parking in your HOAs. But please note that this ultimately is subject to a Kaufman analysis. So it's really important to contact your association attorney to discuss violations, especially as it relates to our parking restrictions. I would not be surprised. We have several associations within our clientele that truly, this is a huge issue. The declaration is a contract between the association and its membership. And, is this a constitutional impairment of our contract rights under the United States Constitution, under the Florida Constitution? Is that an issue here, right? So this is something that I think in the next few years is going to make its way up through the court system. But until then, this is the law. And so just make sure that if you're doing this, you're going to want to talk to your association counsel, as I said, about a Kaufman analysis and, discussing what to do next. The last thing that we just wanted to talk about is, and I kind of brought this up earlier, is about garbage cans. So now the law states that associations cannot enforce, violations for failure to move your garbage cans if your garbage can is there within the 24 hours before and after a garbage pickup day. And I think of it like, imagine if it's one of your bigger associations that could potentially have 2 garbage days. You may only have 1 day to cite this, but ultimately, this is one of those situations where it kind of illustrates that a violation can easily be cured because I just brought in my garbage can, right? So that's something that to think about. But with that, we have reached the last portion of our presentation, which is Hot Topics and Q&A. Hot Topics is essentially going to cover a few items that we want to highlight for you all that may not necessarily fall under the purview of today's presentation, but it's important for you all to note.
Okay, so thank you, Emily, for wrapping up that part of her presentation. That was the bulk of today's course. I'm going to share my screen real quick and I will go over a few quick reminders before I pass it over to Attorney Kelly Welch. Sorry, just one sec. Okay, technical difficulties. Here we go. Okay. So just a few quick important reminders. You've heard this a few times throughout the presentation, but we just like to reiterate this important information. Um, So please allow 10 business days for us to process and issue your certificates. If you don't receive your certificates by those 10 days, then you can follow up by email at marketing@ansbacher.net and just include all of your information. So your name, association, course date, and then we'll be able to send those out for you as soon as possible. And then again, those certificates will only be issued to participants who are present for a minimum of 240 minutes, which is required by DBPR. And then your CAM credits and your real estate credits will be posted if you provided them. If not, then you can also email us at that same email and we'll do that for you. Okay, so just some more important information. You will receive a few different emails after this. You'll receive an email first from Vesta, and that will include all of your course materials. So that includes this presentation that we just went through for the whole 4 hours. And then after that first email, we will send out another email on our end with your certificates. Now, you may get your certificate in your spam folder or your junk folder. I know that happens sometimes, so please make sure to check that. And if you do not receive them or you can't find them, feel free to reach out to marketing@ansbacher.net as well. And then finally, make sure that if you are in a webinar or in a group watching this webinar, then have your host fill out this form to receive your credit. And you can also email us for that form as well. Okay, perfect. And now we are on to our hot topics question. So I'm going to stop sharing and pass it over to Attorney Kelly Welch.
Hello, everyone. Like Isabella said, my name is Kelly Welch. I'm one of the attorneys here on our Community Associations team at Ansbacher Law. I will be covering the hot topics and Q&A section of our presentation today. Luckily, you have made it through the majority of our presentation, and thank you so much to all of my colleagues and the other presenters who have done an amazing job today. I also really want to thank all of you for hanging in there and spending all of your day with us today. I know it's been a very long day. And after I wrap up the hot topics, we'll do some live question and answers of some of the questions that you've submitted to us through the Q&A chat at the bottom and some frequently asked questions that we get. And I know it's been a really long day, but I do want you to think back early on in the presentation. Do you remember we discussed how a bill becomes a law and where you can go to view those proposed bills that are making their ways through the chamber? Those proposed bills are ultimately presented to chambers where either the House or the Senate will vote on whether the bill should pass to the next chamber or to the governor, depending on where we are in the process. This occurs within the first quarter of the year, and as discussed this year, this session began on January 13th, 2026, and then ended somewhat recently on March 13th, 2026. As you may have guessed, today's hot topics will be centered around the proposed legislation affecting community associations. I do want to remind everyone, and this will not be the last time that I remind you, that not all of these bills are the current laws. Some of the bills that I will discuss did not survive the legislative session and will not move forward to become a law. That is because the legislative session recently ended, and it is important still to talk about the bills that didn't pass and didn't make it through, because it's important to know of potential changes that the legislature is contemplating regarding community associations, because some of the changes that they've discussed here this last legislative session may come up again, and they may consider the same bills or policies for the future. And I do want to stress the importance of staying updated in what's going on in the legislature and being involved in understanding what is going on and what may affect you and your association. It's really important to get involved because you can go and make an impact on the legislature should you, go and get involved, know what's going on with community associations. All right, so let's get started here. The first proposed legislation that I want to highlight for you all is House Bill 465 and its identical companion bill, Senate Bill 822. This proposed legislation would essentially require any condominium association, co-op, or homeowners association with $750,000 or more in revenue to contract with a community association management firm. Now, this bill did not make it through the legislature. However, if it comes up again, our opinion is kind of that this would be a good thing. I would imagine that many associations that fall under this category for requiring them to contract with a management firm just hones in on the idea that the operation and management of associations can be difficult, and having a dedicated manager can only assist the boards and help with compliance and day-to-day operation of the association. Now, to piggyback off of that concept, now multi-condominium associations must contract with a community association management firm. So this is different than the revenue trigger. Essentially, if your condo is a multi-condominium, regardless of the revenue, they would be required to contract with a management company. This bill would also require HOA directors and officers to ensure that their community association managers are licensed. However, this bill did not survive the legislative session. It is not going to become a law this year. However, as I mentioned before, it's really important to be aware of these laws. It may come up in the future again, and it is really important to kind of keep an eye on what's going on in the legislature. Also, I do want to add, I'm seeing some questions in the Q&A about whether the course is over. You do have to stay logged on for the full 240 minutes, so until 2 o'clock. So this course is still going, so please stay logged on to ensure that you get your certificate from us. Zoom will track how long you've been logged on, and we are able to see that to be able to give out the certificate. So please do not log off yet. And so for the next, like I said, this bill is dead and it will not continue on. Now to keep going, the next bill to discuss is House Bill 657. If you have heard about any bills affecting homeowners associations, this is probably the one that you've seen in the news. I will say that this particular piece of legislation has everyone in the community association legal field up in arms. This bill would require all newly formed homeowners associations, those formed after July 1st, 2026, would need to include Kaufman language in their declaration. Now, think back to a few hours ago when we talked about Kaufman language, and that is the magic phrase as amended from time to time. This language, if included in the declaration, essentially automatically adopts new legislative changes to the association as if it was already included in their governing documents. Now, if you're here, it is likely that your association has already been formed, but this bill also contemplates that idea. If this bill were to be brought up in the future and passed at some other time, as this bill did not pass the legislative session this year, it would require that associations that are currently in existence would still need to hold a membership meeting to vote on whether to amend their governing documents to include that Kaufman language. And if a majority of the owners voted in favor, the declaration would be amended to include the Kaufman language. This bill also contemplates alternative dispute resolutions. HOA election disputes would continue under the jurisdiction of arbitration with the DBPR, and arbitration and pre-suit mediation, which would also affect condos, would now be replaced with a community association court program. Essentially, all disputes would be subject to the jurisdiction of the community association court program. Now, I know you all may be very confused by this, and just know that you are not alone. So am I, and so are a lot of association attorneys throughout Florida. It is very difficult to ascertain how this idea would actually be implemented. However, since this bill did not pass, we don't have to think about it too much. It may come up again in the future, and maybe there'll be a better idea about how this would be implemented. And then again, this bill also contemplated a very hot topic of termination of a homeowners association. As you may know, Florida Statutes Chapter 718, which governs condo associations, already contemplates the termination process for a condo. However, Chapter 720, which governs HOAs, has been silent about termination and dissolution of the associations. This proposed law provides that if 50% of the members petition the board to terminate the association, the board would then be required to hold a meeting to discuss the petition or the termination within 60 days of receipt of the signed petition. Notice of that meeting has certain requirements, which includes copy of the proposed plan of dissolution, an explanation of how the common areas and the assets of the association would be managed or transferred. If that meeting does not occur within that specific time frame, then the members can petition the Community Association Court Program, which I just discussed, to issue an order compelling the association to call the meeting, or if that program doesn't exist in that jurisdiction, then the members can petition a court of competent jurisdiction to do the same. And moving right along, that plan of termination would require a 2/3 approval of all voting interests in order to move forward with termination of the HOA. If approved, the plan must be submitted to the Community Association Court Program or a court of competent jurisdiction if that does not exist. And if the plan is approved, the assets are vested in a termination trustee, but the board would continue. Now, as I said, this bill did not survive the legislative session, but it was voted for 108 to 2 in favor. So there is a chance that this could come up again in the future, but it did not pass both of the houses. Now, finally, the only bill to make it through the legislative session this year, which affects HOAs and condos. This is a change pursuant to HB 803, which changes Florida Statute Section 720.3035. This change is currently waiting on the governor before it becomes law, and this would change the Architectural Control Committee and its guidelines. Oops, sorry about that. This change would state that an association or one of its committees may not require a building permit to be issued as a prerequisite to the association reviewing proposed plans, constructing structures, or improvements on a parcel. All right, now, as I said before, please make sure to stay on to this Zoom for the full 240 minutes that we have. If you do not, then you will not be able to get your certificate. So please stay on, stay with me. I know it's been a really long day, but I am going to start going over some question and answers that we got from the chat. I first off want to start with discussion of continuing education requirements and the board certification requirements for board members. I know this really frequently comes up and it can be a little bit confusing. So within 90 days of being elected to the board, you must get your board certification course. This course is approved for board certification course. That certification lasts for 4 years for HOAs and 7 years for condos. And if you are continually serving on the board for multiple years, if you take the course and you're on the board for 3 years, then it's still valid, it's still good. However, if you jump off the board and you come back on, you should take the course again once you're within 90 days of being reelected. On top of that course, all board members have continuing annual education requirements that they must do. For HOAs, that is either 4 hours or 8 hours, depending on the size of your association. For associations that are 2,500 parcels or fewer, it is 4 hours, and associations that are more than 2,500, it is 8 hours that must be completed every single year. And for condos, you just have a 1 hour continuing education requirement, and that course must cover legal updates regarding Florida statutes, Chapter 718. Now, we have courses that work for all of that. This course right now is approved for board certification, HOA continuing education, and condo continuing education. So you should be covered. And we have multiple other courses such as legal updates and others that will also work for some of these courses. But please keep in mind that if you are here right now for your board certification course, you cannot double dip and also have it count towards your continuing education. You will have to take another course to get your continuing annual education requirements. All right. Now, moving on, I am going to talk about some official records. I saw a lot of questions regarding this, so I just want to go over it another time about what records have to be retained and for how long. So, to briefly cover this topic again, condos must have their official records be maintained in an organized manner that facilitates inspection of records by a unit owner. As we discussed before, this is very vague and unclear on what this actually means, but use your best business judgment to keep your records organized. So when an owner comes in, wants to inspect and copy the records, that it is facilitated in an organized manner. So the documents that must be kept permanently or forever for a condominium are the developer documents, the governing documents, and meeting minutes for any board or membership meeting. Now, for 15 years, a condo association must keep the milestone inspections and the structural integrity reserve studies. Any documents relating to those, keep them as an official record. For 7 years, condos must keep all other records. So the default for most records in condos is at 7 years, but please keep in mind the forever and the 15 years for certain documents. And then there are very few documents that you are allowed to keep for only a year, and that is election voting materials and contracts or bids. Now, for HOAs, all official records, unless the governing documents of the association require a longer period of time, which is very, very important to keep in mind. Please review your governing documents, talk to your attorney, make sure that you are keeping these records for the proper amount of time. But all of those records for HOAs is 7 years that they must be retained. And then, just like condos, there's a very small amount of documents that can be kept for 1 year, and that is the election voting materials and contracts or bids. I also want to discuss, we had some questions about what constitutes an official meeting of the board versus unofficial meeting of the board. If 2 board members go and get coffee and, do they have to notice that meeting for the membership to be able to attend? Well, that really depends on your association and how many directors you have. If a quorum of the board is meeting, and that varies depending on your governing documents, then you must notice the meeting if you are going to be discussing association business. So if you and your friend who's a director are going to meet and quorum is not met, you guys can meet to discuss and don't have to notice it. However, if you are meeting with a quorum of the board and you are meeting and you are discussing association business, then that must be noticed for the membership to attend. We also get lots of questions of, what happens when there's an association event and the board members want to discuss while they're there. And that's the same thing applies. If you are going to be talking about association business, you must, notice that for the membership. And we also really caution if you are going to be at an association event and board members are going to be discussing, please keep note, you got everyone around you that will be able to see much more clearly what's going on and be able to possibly try to challenge and say that you didn't properly notice the meeting. Also, I do want to discuss, we get a lot of questions about what emails the association board members should be using, we really, really highly recommend that the association create their own email addresses for the board members and then pass that email login down to the newly elected board. So for example, you could have an email that's associationvp@association.com or at gmail.com. And then it makes it a lot easier to be able to keep track of those emails, because those emails a lot of times will constitute official records of the association. And it can be really difficult to try to track down former board members to get into their email, especially if it's their personal email, to get their emails about possible discussions from years ago. This comes up a lot. So we really recommend the association just designate those emails. And then when a new board member is appointed, you can change the password, give the login to the new board member, and then keep going like that. It really is nice to keep those records completely separate from your personal email because it can get very confusing and all mixed up. Now, we also got a lot of questions about the SIRS and milestone requirements. So the mandatory structural inspections are applies to condos and co-ops that are 3 or more habitable stories in heights. Now, those will require you to get a milestone inspection. It is really important to know that for those condos with 3 habitable stories or more, the milestone inspection must be performed by December 31st of the year in which the building reaches 30 years of age, which that is based off of the date of the certificate of occupancy for the building. And then that association, once it turns 30, must also conduct the milestone inspection every 10 years after. Now, if your building has already reached 30 years of age and you have not completed a milestone inspection, please reach out to your attorney to get going with that, because per the statutes, you should have those completed by now if your association is over the age of 30 years old. All right, and I just got another question. Does a new board member need 4 hours within 90 days and another 4 hours for the annual requirement in the first year they are on the board? If your HOA is 2,500 or less parcels, then yes, you do. I know it is a lot of education for HOAs, but you must complete the 4-hour board certification class, and then make sure, depending on the size of your HOA, you must complete additional within that first year that you're on the board for your annual requirements. I know it seems a little crazy that condos only need 1 hour of continuing education, but HOAs need a lot more, but that's just what's in the statutes. So yes, if your HOA is over 2,500 parcels, you do have a lot of education to do in that first year that you are on the board. And now, just a reminder as well, I see a lot of people who say, they got logged off throughout this course or they lost connection. If you lose connection for a minute and you pop back in, all will be good. Zoom is able to track how long that you've been on this webinar, and it's a total amount of minutes. So even if you jump off and jump back on, if it's for a minute or two, you should be completely fine. If you have any concerns about it, please, email us at marketing@ansbacher.net, and, we can try to figure that out and look it up, and figure it out. But we are getting to the end of our webinar, and I really just want to thank everyone just for attending and for participating and asking all these questions. It really does help us when we're teaching to have the participation and have people asking us questions to be able to answer. So it is very, very nice. Thank you all. And please, we really do appreciate feedback and reviews. Our boss, Barry Ansbacher, loves when you all leave reviews for us, and it really, really helps us. Please remember, though, only 5 stars really do help us, and 4 stars actually hurts us the way that the algorithm goes with Google. If it's a 4-star, then it really dings you. So please, please give us reviews if you enjoyed this course. If you have any feedback, please email us at marketing@ansbacher.net. We always love to know how we can do better on these courses in the future. And thank you all so much for being here. We have reached 2 o'clock, so you have officially been on the webinar for 240 minutes. This course is now over. So thank you so much, everyone, for joining us, and I hope you all have a really, really lovely day. And if you ever need a course again in the future, we have plenty, and you can go to ansbachereducation.com. And thank you so much to Vesta for partnering with us and asking us to do this with them. It was really, really nice of them to think of us, and we love doing these for you all. So thank you so much.